Good morning and welcome to the third edition of the Gender Equality Moot Court Competition. My name is Elizabeth Alukudo. I work at Equality Now as an Associate Program Officer. I want to thank you for making time to be here with us. This webinar has been hosted by Equality Now in collaboration with the SOAWR Coalition and the Kenyatta University School of Law. Please note that we have interpretation at the bottom. Please use the globe to choose your language of interpretation. We have English and French. And please feel free to introduce yourself on the chat. If you have any questions, please use the chat box to put your questions as we continue with the webinar. At this time, please allow me to invite the Africa Office Director, Faiza Mohammed, to just give us the opening remarks as we begin this webinar. Welcome, Faiza.
Thank you, Liz. Good morning, everyone. On behalf of Equality Now, it is my pleasure to welcome you to the launch of the third edition of the Africa Equality Moot Court Competition. Since 2020, Equality Now and the SOAWR Coalition, that's the Solidarity for African Women's Rights, have hosted the Africa Gender Equality Moot Court Competition. It's a unique moot court competition that is principally dedicated to the Maputo Protocol and women's rights in Africa, and is conducted in both English and French with participation from different African universities. The primary objective of this moot court competition is to enhance law students' research, understanding, and application of the Maputo Protocol and other regional and international human rights instruments to advance the rights of women and girls in Africa. The moot court serves as an avenue to enhance the research, comprehension, and application of the protocol to the African Charter on Human and People's Rights on the rights of women in Africa, as well as other regional and international human rights instruments among law students in Africa. Through this competition, we aim to not only deepen law students' understanding of these crucial legal frameworks, but also stimulate their interest in being active advocates for the rights of women and girls. This year's competition will spotlight women's sexual and reproductive health rights, specifically delving into the legal complexities of commercial surrogacy in Africa, a practice facilitated by the internet alongside scientific and technological progress. It is an invaluable educational experience that will significantly alter perspectives and expand comprehension of commercial surrogacy. Commercial surrogacy is a contemporary legal issue in Africa and globally, and the legal landscape on this topic is still largely in its infancy in Africa. Through diligent research, excellent arguments of concepts, and insightful conversations, participants will get a chance to explore and advance arguments on the basis of the detailed and challenging hypothetical case, and ultimately encourage the participants to forge a career in actively working to advance women's rights and cultivate a less exploitative and more equitable community. Therefore, I encourage all the teams that will participate in this competition to exert themselves, engage fully, challenge themselves, and think creatively about the legal issues presented by this year's hypothetical case. The Africa Gender Equality Moot Court Competition has historically been co-hosted with leading universities with a strong mooting culture. We did it with the Catholic University of Eastern Africa. We also did it with the Strathmore University, and this year with the Kenyatta University. As we launch the third edition of this competition, allow me to appreciate these partners and in a special way, the Kenyatta University School of Law for graciously accepting our partnership invitation to be part of this initiative this year, as we strive to educate and inspire the next generation of legal minds to champion gender equality and justice. I would also like to thank all those that have served as judges in the previous Moot competitions and those that will serve in this third edition of the competition. Drawn from diverse fields such as the judiciary, women's rights advocates, academia, lawyers, and legal practitioners, the judges really enrich the competition by lending their expertise in legal advocacy and in thematic women's and girls' rights issues. In conclusion, I would like to extend my best wishes to all the participants. I hope this competition inspires you, challenges you, and equips you with the knowledge and skills to be advocates for the advancement of women and girls' rights. Thank you, and I look forward to a successful launch and a fruitful engagement in the Moot Court competition. Have a lovely day. Thank you.
Thank you so much, Faiza, for the opening remarks. Kindly allow me to invite our partner university, which is Kenyatta University. Kenyatta University was established in February of 2012 with a vision of being a premier law school to educate legal entrepreneurs of conscious competence and compassion with ability to meet the legal writing and research skills. Kenyatta University has a robust mooting culture, which makes it ideal to be a partner in this Moot Court competition. Please allow me to invite Ms. Margaret Kokumu, who's the Registrar of Kenyatta University, to give her welcome address. Welcome, Margaret. Yes, Margaret. As we try and find Margaret. Allow me to invite Esther to just give a brief overview of the expectations of this Moot Court. Esther, are you ready?
Yes, Liz. Good morning, everyone. I hope you are well. My name is Esther Wawero. I work as the Senior Legal Advisor at Equality Now's Africa office. It's really a great pleasure for me and an honor to have all of you joining us today for this webinar as we launch the third edition of the Africa Gender Equality Moot Court competition. I will share a few slides that will help us to better understand this year's AGEMCC. So Liz, if you could please help or Tuva with the sharing the screen. No, I'm not able to do that from my end. Liz?
You just give me a minute.
Okay, thank you. I will just start. So as I will speak about three main things. I'll talk about the objectives of this webinar. I will also speak about the Moot Court competition structure and the theme itself. In terms of the objectives of this webinar, we understand that surrogacy and commercial surrogacy, especially in Kenya, is an upcoming and contemporary area of law, especially with regards to sexual and reproductive health rights. And this webinar, therefore, is aimed to offer insights into the practice and the legal dilemmas of surrogacy in Africa. Secondly, we hope to inspire student engagement, not just during this webinar, but also during the Africa Gender Equality Moot Court Competition 3rd edition, as this is going to be the main theme and the hypothetical question is framed around this. And then thirdly, of course, we will be launching this 3rd edition of the Africa Gender Equality Moot Court Competition. And it's great to see so many people who have participated in the last 2 moot courts joining us today. And Ayeta and Olanike will speak into greater detail on the various issues that need to be considered when we are looking at commercial surrogacy within the ambit of sexual and reproductive health rights in Africa. But just to give you a hint, for us, when we're looking at this theme of the legal dilemmas of commercial surrogacy, some of the things that are emerging from the hypothetical case and which will inevitably emerge from the arguments by the different participants include, for example, exploitation by agencies, the question around the legal protection for children born out of surrogacy arrangements and the rights that accrue to them. Thirdly, the transmission of prenatal rights and everything that surrounds the care and prenatal services to surrogate mothers. Fourthly, the question around the enforcement of surrogacy agreements. And fifthly, pregnancy complications and multiple births. How are these issues dealt with when it comes to commercial surrogacy? But more importantly, the hypothetical case that has been framed for this particular competition is one that offers great social and legal intrigues that are going to really challenge the participants and get them to a place of researching and contributing to this discourse that is, as I said, is growing on the African continent in terms of framing in terms of looking at even the lack of, mostly in Africa, of legal frameworks around commercial surrogacy. And this case therefore presents, so many angles of arguments that will help us to really elaborate the issues and the legal dilemmas around commercial surrogacy. The competition structure is as follows, as we will mirror the competitions in the previous years. So we start with the drafting and submission of memorials, which of course will be preceded by the registration. And we'll talk at the end of this webinar, we'll be discussing how, we will be launching, receiving registrations and so on. We'll also then proceed at the second stage to the judging of memorials. And we have 3 knockout stages or levels of competition. The first level of competition is at the memorial stage. So participating teams will be judged at the memorial stage. And then those that, qualify from the memorial stage will then proceed to the preliminary oral pleadings and hearings. After that, we will have the semifinals and the finals, which will be held in Nairobi, Kenya, at the Kenyatta University School of Law premises. The preliminary rounds, I should say, will be held virtually, just as we did last year. It's only the semifinals and the finals that will be held in person, with only those qualifying teams traveling to Nairobi for that. And then we will close the competition with an award ceremony where we will be issuing the awards and the prizes to the winning teams. With regards to drafting and submission of memorials, we will be sharing a link on our website, the Equality Now website, that will greatly explain the procedures for this, at least for the new entrants in this competition. But basically, each participating team is required to prepare memorials for both the applicant and the respondent side of arguments. And we are strictly requiring that no other person may assist the team with researching, writing, editing, or otherwise presenting arguments during the competitions. We will provide an email address to which you can send all the pleadings and any questions or inquiries that you have with regards to the moot competition. Specifically for the memorials, we are asking that this be sent as a single file in PDF format by the 10th of September this year. No changes can be made to these memorials after they have been submitted. And of course, there will be a penalty for late submissions, where the team that submits late will be deducted 1 mark per memorial per hour of late submission. Documents, of course, that will be received 12 hours after the lapse of the deadline will not be considered. At the level of judging the memorials, it is important for us to note that memorials account for 50% of the overall score for each team. And we have provided a scoring criteria, and we will also upload the rules for the competition, just so that you can, the participating teams can always go back, review these rules. They are available in both English and French. For the preliminary oral pleadings and hearings, as I said, this will be held virtually on Zoom, as we have done in the past. Again, these rounds will be held both in English and French, and we're encouraging, as many teams, both Anglophone and Francophone teams, to register and participate in this competition. During the preliminaries, each team member will make their oral proceedings from different locations, and we will try to coordinate with the students to ensure that they are able to effectively and successfully compete at the oral rounds. This is, we have details on how that will be done once you have registered. Again, just to note that oral pleadings again count for 50% of the total score per team, and teams will be expected to prepare, again, as with the memorials, for both the applicant and the respondent sides. Yeah. We have allocated time as 30 minutes for presentation of arguments, including time for answering questions from the judges, and also allowing for rebuttals and surrebuttals. We will have a first round, oral rounds, where the applicant will proceed, and then the respondents, and finally followed by the applicants, or anyone oralist can then make the rebuttals or surrebuttals. Judges may, at their discretion, extend the time for oral pleadings, and this again differs from bench to bench and from team to team. It's, as we say, it's at the judge's discretion, of course, considering certain factors, for instance, network, internet outage, or electricity, power blackouts, that kind of thing, to be able to allow the teams to make their submissions effectively. The judging and scoring of the oral submissions or pleadings will happen immediately after each round. And so the judges will be encouraged to send in their scores at the end of every round. There will be 3 judges who will sit and listen to each participating team at each round. And the oral pleadings will be marked on a maximum of 100 points by each of the judges, and thereafter tabulated. Each oralist can be awarded a maximum of 50 points per oral pleading based on on the following elements: clarity and logic, legal analysis and sources, problem recognition and argumentation, oral thought and presentation and rebuttal skills. This is a very quick snapshot of what the rules say, and we'll encourage everyone to look at the rules once they are uploaded on our website by the end of tomorrow, ahead of the launch of the Moot competition for registration, which will happen on Monday. Again, just to remind us that we do have a dedicated email address for any questions that you might have regarding the Moot competition. And at the end, when we're sharing the next steps, we'll be getting into greater detail on how you can get in touch with us and where you can find all the information. Thank you so much for listening to me. And if you have any immediate questions, please feel free to use the chat, and we'll be sure to answer your questions. Thank you so much, and back to you, Liz.
Thank you so much, Esther, for that precise presentation. Please also, as I welcome the next presentation, please remember to put your questions in the chat box. And right now I'm going to invite Miss Ayeta Lumbaso. She's the CEO and founder of Fertility Law Center based in Nairobi. She's going to take us through just to understand commercial surrogacy. What are the legal and ethical perspective of commercial surrogacy? If you're ready, please welcome Miss Ayeta.
Good morning, good afternoon, good wherever, evening, wherever you are. Ayeta Lumbase is my name. Let me just put this here. And I'm going to be very fast. If I'm too fast, just stop me, either by stopping me literally or asking the coordinators to put a stop to me and to let me know. So I'm going to start sharing my screen so that we can get into this. So I assume we know what surrogacy is, being that we are doing a moot court on surrogacy. I am assuming we know what surrogacy is, but I'll just briefly go through what surrogacy is so that we are on the same page. So when I was doing my master's, one of the things that I was told is to quote a Bible verse or a religion verse when I'm trying to present as one of the things that, to encourage people to not only view this as a reproductive health thing, but to also view it as a human rights kind of thing. So behold, children are a heritage from the Lord, the fruit of the womb a reward. Like arrows in the hand of a warrior are the children of one's youth. Blessed is the man who fills his quiver with them. That is from the Bible. My screen is not going. So what is the background of surrogacy in Kenya or in Africa? In most African communities, we do understand that surrogacy was perceived as an informal arrangement where traditional practices, like polygamy, people who didn't have children in the old society were told, why don't you just, go sleep with, say, somebody else or take your sister's children or do that instead of going to, adoption was kind of part of the surrogacy. And in fact, people were allowed to marry their husband's brother to take care of their nieces and nephews. To take care of their nieces and nephews so that surrogacy can go into place. My Nini has stopped sharing. Let me just share it again. There it goes. So what is the right to reproductive health? I always like asking, do human beings have a right to reproduce? Do we really have a right to reproduce, or are we just putting this on ourselves? Do we have a right to procreate? And what is the difference between procreation and reproduction? And if we do have a right, what are the corresponding duties? And is infertility a health or a social issue? Bearing in mind that sometimes we go ahead and have children, not necessarily because we want to have children, but because as a woman, you've been married, you've been in a marriage for a certain period of time, you are required essentially yes?
Please allow me to stop you a bit. You're too fast. If you could slow down because of interpretation. Thank you.
Oh, okay. I'm trying also to get, let me just... Yeah, okay, so I will stop. I will restart. So do we have a right to reproduce? That is where I was. And is infertility a health or social issue? And if it is a health issue, or rather, if it is a social issue, should we legislate on matters to do with reproduction and procreation, or should we just leave them as bedroom matters and proceed as we wish? That is something that we need to put in mind as we consider this conversation. So surrogacy. Basically, surrogacy is an arrangement often supported by a legal agreement where a woman who is the surrogate mother agrees to bear a child for another person who will become the child's parent after birth. It is essential to realize that there are two women in this process, sometimes three if an egg donor is used, but there are two women where one is carrying the child, but this person carrying the child is not necessarily going to be the mother of the child. She's going to bear the child and give to this other party who is going to be the child's parent after birth. It is basically the practice where one person carries a child for another with the key intention as lawyers or determinant lawyers, people who are studying to become lawyers, you know the word intention is very key when doing anything. So the intention behind surrogacy is that the child that has been born will be handed over after birth to the other party. It is important to note that this is a third-party treatment option. Why I'm saying it is important to note this is third-party treatment options for infertility or for any other kind of treatment essentially require consent every step of the way. Every step of the way. Third-party treatment, you're involving a third party, so you require consent, informed consent, every step of the way. So what are the types of surrogacy? Basically, ideally, we have two types, traditional surrogacy and gestational surrogacy. However, under the two types, there are the other three types that fall into that. They can either be altruistic surrogacy, altruistic traditional surrogacy, or altruistic gestational surrogacy, or full traditional surrogacy, or full gestational surrogacy, or full traditional commercial surrogacy, or full gestational surrogacy. So all the three parts that I have put underneath here can fall either on traditional surrogacy or gestational surrogacy, but ideally there are only two types, traditional surrogacy and gestational surrogacy. The traditional surrogacy can be traditional commercial surrogacy. The gestational surrogacy can be gestational commercial surrogacy. So what is traditional surrogacy? This is where the woman who carries the baby is also the provider of the egg. Usually this is a gentleman's agreement and it is not enforced in very many countries, and actually most countries do not allow it because the surrogate is actually the biological mother of the child as well, and as such she's not only the birth mother, she's also the biological mother, the legal mother, and has all the rights and responsibilities towards the child. In fact, this is just achieved sometimes through direct physical contact. You can decide somebody can sleep with your wife or with your husband, or you provide sperm and you do IUI either through a hospital or by yourself. And then it is guided by a gentleman's agreement and it does not require enforcing. And usually it is unenforceable because you do realize that this woman is also the biological mother of the child. So to give up your biological mother, to give up your biological child, that would not necessitate it to be a surrogacy engagement. So this is very hard to regulate and it only usually happens in family setups. You tell your sister, please give birth on my behalf and then I'll take care of the child. This is traditional surrogacy. The intended mother is also the surrogate mother, so the egg is hers as well. And then from the intended father, you collect the semen, and then the mother, who is the intended mother, who is also the surrogate mother, is the one who does that. So that one, we rarely practice it in Kenya because it is unenforceable. In other African countries, Ghana does not practice it as well. I'm not sure about Nigeria and others, so maybe you will give us what usually happens in those other countries. Gestational surrogacy is where the child is not biologically related to the surrogate mother. It is also referred as to gestational carrier. Instead, an embryo is created through IVF using the eggs of the intended mother or of an egg donor and the sperm of the intended father or a donor, and this is transferred to the surrogate mother. Whatever embryo is created is transferred to the surrogate mother. It is important to note that gestational surrogacy is the one that is widely acceptable, not just in Africa, but world over, because the intention behind this is actually that you're going to use your embryos to be carried in by another woman to give out. And then once the child is born, you're giving out this child to the intended parents. It is essential and even advised that at least one of the intended parents is genetically related to the child. This is for parentage. This is for issues about origin, because what is the issue? What is the point of having an egg donor, a surrogate, and a sperm donor? You know, you're having an egg donor, a sperm donor, you create an embryo and you transfer these embryos to a surrogate, and the surrogate gestates and gives birth. Ideally, this child has no heritage. This child has no origin. This child, we are literally creating problems by trying to solve other problems. So in this situation, we always advise that at least one of the intended parents is genetically linked to the child. Either the father produces the sperm or the mother produces the eggs. This was first achieved in April 1986. As law students, you would be knowing about baby M case. That was the first surrogacy case in the world that came into being, and I would advise you to look into it and know some of the principles that were created through this case. So this is the gestational surrogate. First of all, we start by ovarian hyperstimulation of the person producing the eggs. We do retrieval, then we fertilize the egg and the sperm preparation, then fertilization happens, and then we transfer the embryo into the prospective mother, who is the surrogate host in this situation, and then a pregnancy is achieved. So commercial surrogacy, I said it can be either traditional commercial surrogacy or gestational commercial surrogacy. Commercial surrogacy is a situation where the woman, the surrogate, is compensated for her services beyond, keyword, beyond reimbursement for adequate expenses, which include medical expenses. So basically, this is just a deviation of altruistic surrogacy. You know, altruistic surrogacy is a surrogacy arrangement in which the woman volunteers to carry a pregnancy to term without receiving any compensation whatsoever, unless maybe perhaps it's just reimbursement for medical expenses. But commercial surrogacy is where now you're giving the woman more money beyond the adequate expenses that are required for a surrogacy treatment. So commercial surrogacy, sometimes we call it womb for rent, you know, renting a woman, renting a womb, and stuff like that. It has a lot of negative connotations towards it. And this is just the picture that I thought a little bit sensible to describe what it is. So briefly, surrogacy needs to have a medical condition for you to do surrogacy. The medical conditions can be absence of a uterus, significant uterine disease, repeated IVF failure, absolute medical contraindication to pregnancy. Perhaps you have hypertension or cancer, or you are a multiple organ donor, or biological inability to conceive or bear a child, like in South Africa. They allow gay males, you know, to marry, and since naturally they do not have a womb, they would be ideally good surrogate candidates in this situation. In Kenya, we do not practice gay surrogacy because our laws kind of prohibit gay marriages. And then, of course, age. So these are the wherevers. So the key requirements for surrogacy, just before we go into the legal requirements, key requirements, medical clearance for surrogacy. You do not want to use a woman just for the sake of using a woman. Oh, I do not want to grow fat. I do not want, I don't know, to go through labor and stuff like that. And other people have other very absurd reasons why they do not want to give birth. So you must have a medical clearance for surrogacy. Some of the medical clearances requirements are the ones that I've just specified above. And then there has to be a genetic link to one of the intended parents, either the mother or the father. As we have said, it is important so that the child has heritage, the child has an origin and stuff like that. And then there has to be a written surrogacy agreement in the country of treatment. It is important to note that a surrogacy agreement is not enforceable. Just like donor agreements, you cannot enforce an agreement. If I'm doing a kidney donor, perhaps, and we enter into an agreement, you cannot enforce a donor agreement. But it is a persuasive tool to show the intention behind the process. That is why every surrogacy agreement, if you appear in court, whichever country it is, be it in Nigeria, be it in Kenya, be it in Ghana, be it in South Africa, be it in the USA or UK, the agreement will play into the decision that the judge has to make according to each specificity of the agreement. It is a persuasion tool and it shows the intention behind it, but it cannot be enforceable in totality. So you can say, you said you'll pay me 600,000, you have to show reason why and stuff like that. So let's get to the gist of the matter, the legal and ethical issues on surrogacy. We'll start at the core level. Before you start surrogacy, it is important to know that there are three parties to this process. There is the intended parent, mother and father. There is the surrogate mother. Perhaps sometimes she has her husband. And then, of course, there are the professional involved. So the key people here are the intended parents and the surrogate host. So when I say autonomy and informed consent, that there has to be at the core level before you even enter into the agreement, there has to be autonomy and informed consent. What am I talking about? This consent has to be gotten voluntarily. When I say voluntarily, you will realize that sometimes we use our own family members. Maybe my small sister will gestate for me. We use our family members. And sometimes the voluntariness is not really per se voluntarily, because this is my small sister and she understands that if she does not carry for me, perhaps I will not pay her school fees. You know, there's a lot of paternalism that goes on, especially for commercial surrogacy in Africa, because we use family members. We use our house girls, you know, we use people who do not have the equality to argue and negotiate for themselves. So you find that they are entering into this not necessarily voluntarily, but because paternalism has been acquired through it. And then there has to be capacity. This person has to really know what she's entering into. She has to know the risks and benefits, if any, that will accrue through the surrogacy agreement or through the surrogacy arrangement. Sometimes we just tell them that you will get this amount of money at the end of your period. However, we've not told them that they may even die when carrying, gestating. They may even lose their wombs through the process when they're getting into the process and, you know, caring for somebody else, and then they have a complication and they have to lose a womb through the process. And, you know, so when they're entering into the agreement, maybe they do not even have the capacity to do that, because perhaps it's my small sister, as I said, paternalism also comes into play. And then understanding key benefits, key risks, every step of the way. As I keep saying, and I will say it again, this is third-party treatment. Infertility treatment in Africa generally is not priority treatment, unless for South Africa alone. It is not priority treatment. In fact, it is not even secondary treatment. It is tertiary treatment. It has put together with things like plastic surgery. So you can imagine, for every step of the way, you need to get consent, both from the parties, the intended parents, and the surrogate. Just transferring embryos into a surrogate without getting the autonomy and informed consent is also very wrong. So there's also an element on confidentiality and privacy. We know, as thankfully as an African society, fertility matters are still private matters, and we have a lot of confidentiality and privacy issues in it. So it is important. We usually tend to keep private and confidentiality towards the intended parents, but it is important also we consider the confidentiality and the privacy of the surrogate. Perhaps she does not want to be known that she's getting into these processes. So this idea of advertisement, you want to advertise, you're running a center perhaps for surrogates, and you are postering their pictures. This is Emily, she's 34 years old, she has 20 children, or 3 children, and stuff like that. There has to be an element of privacy to it. Even if you're going to do that, can you do it in a matter that is a little bit more private? Because she's not, a surrogate is not a goods, it's not a chattel that you're trying to sell. So you really have to consider the way you're going to advertise, if your country allows advertisation. Like our country, we at the moment, even though we do not have laws on surrogacy, we have medical laws which do not allow for advertisement of certain services. And then the third issue, still at the core level, eligibility. A lot of legislative frameworks, including Kenya, Tanzania, Uganda, Nigeria, I think, because Nigeria does not allow gay laws, also restricts on eligibility. You will realize that gay persons are not allowed to have families, are not allowed to marry, and as such are not allowed to have families. In Kenya, our constitution is very clear. It actually says you are allowed to marry, and it goes ahead and found a family, and it even goes ahead and specifies the kind of family that you're allowed: a man, woman, and children. And as such, this is a little bit restrictive at the core level, because of course, gay parties or perhaps single gay men will not be allowed to access eligibility, surrogacy treatment. This also goes into accessibility. Surrogacy is an expensive affair because it is an offshoot of IVF. IVF is, I think, at the minimum is around $6,000. That is a lot of money. So people who are not able to get that money will not be able to access such kind of treatment. And then most importantly, exploitation and inequality. From the recruitment process, the girls that we are getting for surrogacy treatment in Africa generally are usually from low class, are usually people who cannot negotiate for themselves, are usually people who are so poor that they will literally go through a lot of issues and go through hell, quote and unquote, to just get the monies. So they will put up with a lot of issues. And we have seen this with the agencies that are mushrooming. In Kenya right now, I can tell you a lot of agencies that used to be in India, that were banned in India, have literally set ground here. And they are doing this, exploiting these girls. Some people are actually just putting them in homes and making them as baby factory, baby factories and stuff like that. So exploitation is also, especially from agencies and even from some fertility centers, because you will negotiate for a girl $600,000 or $6,000 and give the girl $4,000 and keep for yourself $2,000 as agency fee. You're not supposed to benefit from a surrogacy program, but you're benefiting $2,000 at the expense of the girl who's taking care of that. At the treatment level, what are the legal and ethical issues? Number of embryos transferred. In Africa, this is something that happens a lot in Africa. We tend to transfer more than one embryo, basically because for two reasons. One, IVF treatment is very expensive. So we are trying to maximize on the number of, success rate. So you transfer more than 2 embryos. Sometimes you even transfer 3 embryos. And even in some situations, 4 embryos, and you find a poor girl, some 26-year-old, carrying 4 babies, 3 babies, triplets, and her body cannot sustain it. So she has to go through other issues, which are also legal and ethical, like embryo reduction or abortion and stuff like that. So we are just putting risk on risk instead of just taking care of these things from the word go. So it is important we actually have laws and regulations that can streamline some of these things, like how many numbers of embryos should we transfer? And is it safe? And the risks associated. Have you told this girl that you're transferring more than 1 embryo? Have you let her know that she will have a multiple pregnancy, and a multiple pregnancy comes with its own medical risks? And has she consented to it? Or just by virtue of having a surrogate agreement, you now think that you will go ahead and just, do whatever you wish to do, both for the medical practitioners and the agencies? That is something we really need to come into play. And then right to treatment information. This specifically for the surrogates. We do not tell the surrogates what kind of treatment we are giving them. You just put a surrogate on hormonal treatment. They are going through the treatment. The agency is the one that is taking care of the information. The information is so public and so private. It's being shared by persons who are not even healthcare practitioners. And there's a lot of privacy data that is being shared that is not supposed to be shared. So they have a right to treatment information every step of the way. Tell them that you're injecting them with this and this hormone. It is supposed to do A, B, C, D, and these are the side effects and what happens after that and stuff like that. Another legal and ethical thing is the status of embryo vis-a-vis the surrogate host. Sometimes you find that there arises a situation where a medical practitioner needs to either save the surrogate or the child that the surrogate is carrying. And this, in usual practice, it is very important. It is very easy to choose. You always save the person who is already alive, meaning the mother. And also sometimes you have to save the person who the prognosis is good, the person who will be able to survive. So in most situations, they usually save the mother. But in this situation, we have 2 mothers. So this surrogate is not essentially the mother to this child. So you find some clinics rushing to save the embryo or the unborn child at the expense of the surrogate host, or making decisions. Perhaps you want to do surgery on the unborn child and making decisions to put the surrogate into more danger. Yet she is the one that is supposed to be protected at all costs because she's the one who is already here. And she's the one who has the basic rights, the one who already has rights. The unborn child, depending on the country that you come from, the status of when life begins, like in Kenya, life begins at conception. So, but when you have a situation where it is an unborn child and already a living mother, then of course the mother comes first. So this is something that we also need to look into. Right of origin, genetic link. I will emphasize on this a lot and a lot and a lot. Let's stop creating children that do not have an origin. Children who are birthed, who are created, quote and unquote, by an egg donor, sperm donor, surrogate. They do not belong to the eggs, to the intended parents. They do not belong to the surrogate. These children will just grow up having a lot of issues. Let us have children, create children that have at least a genetic link to either the intended father or the intended mother, because they're being carried by a third party. So at the final level, what are the legal and ethical issues? We have issues of,
Ayesha,
yes.
if you could still just go slowly a bit for
Oh,
interpretation.
oh
Yes,
dear
we
God.
try.
And I'm
Thank you.
literally, okay, let me just try. At the
Yes.
final stage, we have the parentage and citizenship. You do realize that parental accrual of parental rights, this is two parties. There's the birth mother and there's the legal mother. The birth mother is the surrogate. Medically, whoever brings forth a child is the mother. So medically, the surrogate is the mother of the child. However, legally, whoever owns the child, either through the gametes, eggs and sperm, or through the surrogacy agreement, is the mother. So we do have two different sets of parents, the surrogate hosts and the intended parents. So a lot of countries in Africa do not have laws of transferring parental rights from the intended to the intended parents from the surrogates. Some have to go through adoption, and it is double stigma actually having to birth your own, going through infertility treatment, and then at the same time adopting your own child, a child that was brought forth using your own gametes. So this is something that we really need also to ensure that comes maybe perhaps in the laws and stuff like that. And citizenship as well. You find a lot of foreigners. There is cross-border surrogacy, a lot of foreigners, either through stringent laws in their countries or because Africa is cheap, they're coming to Africa to do a lot of surrogacy. And you find once they have done that, surrogacy citizenship is transferred in most countries through the mother. And who is the mother here? Are we saying the surrogate is the mother? Is this child being conferred upon citizenship by the surrogate? Or are we saying the intended parent is the mother? And this is something that we need to put into play. Post-gestational treatment. Once the surrogates have given birth, what is the follow-up process? Do we even have a follow-up process? Do they even go through psychological analysis? Do they even go through counseling? Do we even follow up to find out that yes, their wombs are okay, that they can give birth, and most importantly, postnatal depression. It is something that is happening a lot, and a lot of surrogates are getting into situations where they're depressed after giving birth, not just because they gave birth and weren't treated, but because it is very, very, it is a little bit upsetting giving birth and giving out the child without going through the necessary counseling situation. And this is something that needs to be taken into wherever. So cross-border surrogacy, I've seen somebody's going to talk about it. So I will leave the reciprocity issues. We will talk about it. So what others? Commercialization. And this is the gist of our issue. Commercialization in surrogacy has grown a lot. Either because the ladies do not have consent, either because they do not have knowledge of what is going on, or either because they're just being swindled by the agencies, or because they have unequal rights. They cannot be able to negotiate their own terms and pays and standards. They cannot be able, they're not on the same standard with the intended parents. And as such, commercialization of surrogacy has become a lot in Africa. One key issue why there's a lot of commercialization is because of lack of laws. I will say that only a few countries in Africa have IVF and surrogacy laws. Two among them is South Africa, which has a very detailed act that talks about surrogacy, talks about IVF in general, and how to transfer parental rights, and what even needs to go into a surrogacy agreement. Ghana in 2020 passed an amendment in their Birth and Death Registration Act, and as such has one of the laws in Kenya. In Africa, Kenya does not have a law yet. We still have bills which have been in place since 2014. Every year we keep changing something small, we keep changing something small. Same to Uganda. They say they're going to do a surrogacy arrangement act, and they have not already passed it. So commercialization has two aspects. They're there are issues that people argue against and issues that people argue for. Some of the issues they argue against, which I think is true, is exploitation. There's a lot of exploitation. These girls are exploited. In Kenya, I have seen some places where agencies actually even take the girls out of the country and put them in very dingy places, so that they can just be able to escape some of the citizenship and nationalization issues. And these girls, once some of them even come back as dead people because they were not even taken care of there. And also the issue of dignity. What kind of dignity are we giving these girls when we're putting them through commercialization? What kind of dignity, they don't have the rights. We are treating them as non-humans. So commercialization, an argument against commercialization is also the issue of treating the girls with no dignity. And then the risk for distinction in pedigree. If we say that, say, Ruby is going to carry, my other name is Ruby, is going to carry for somebody, and we are going to pay her $10,000 because she's a lawyer. And say Nora, who is my house help, is going to carry, and we are going to pay her $3,000, the difference of $7,000, basically because I'm a lawyer and she's a house help. So apart from dignity, we are also trying to put a distinction in pedigree when it comes to commercialization. You are putting a price on a girl, a chattel. It's like if you go to Amsterdam and you find those girls in glasses, you know, selling their wares, trying to get clients for their sex things and stuff like that. So this is what commercialization has done. It is exploiting the girls. It is putting them at risks for distinctions in pedigree. It is most importantly allowing child trafficking, especially on the surrogates part, because if you're going to pay me 10,000 and somebody offers me 15,000, what makes you think that I will not just hand over this child to this person who is giving me 15,000? Because all I want is money from you, you know, and stuff like that. So some of those are the arguments for against commercialization. And arguments for commercialization is there's justice. You negotiate whatever amount you want according to your desire. However, we need to put it to really realize that these girls do not have there's necessary equality or rights or standards as the intended parents. So even if we say justice, that they're going to negotiate for a pay that is commensurate with their service, they are not on the same standard. So the negotiating table is already tilted against them. So it cannot be that they're negotiating for their standard. And most of them even, you know, work through agencies. So it's the agency that is putting a price on the girl to negotiate for the price that the agency thinks the girl is worth. And then another argument for is that they get a reward for the service that they do. What kind of reward? You can never put a price, in my opinion, you can never put a price for caring for somebody. So I do not understand the kind of reward that this person is getting. If I am giving you some compensation, it is because you're caring for me, a child, you're caring for me, a pregnancy that I am not otherwise able to. So it is not a reward, in my opinion. It is just a service that came into play and I'm paying for it. And then another argument for is that it promotes reproductive tourism. I don't know how positive that agreement is, because I do not see how putting the girls at risk and exploiting them and put, you know, splitting, literally getting out their dignity and, you know, is a good thing for promoting reproductive tourism. Perhaps we should just do other kinds of tourism other than reproductive tourism. So another element is commodization of children. Child trafficking. We know Africa, especially countries like Kenya, Nigeria as well, and a few other African countries are red flagged. They are not only the source, but they are also the destination of child traffickers and children who have been trafficked. And surrogacy has been cited as one of the ways that is promoting child trafficking. This is because we do not have laws. There's a lot of under the water kind of transferring of parental rights. People without laws do not even have to appear before court. There's so wishy-washy ways of transferring parental rights. You just go to a hospital, they write for you a birth notification in your name, and you say, oh, Ruby was my surrogate, this is my child, and you get a birth certificate, and you leave the country or town or wherever it is and go with the child. We have no ways of following up to see that was this child truly this person's child? Was this child, is this child safe, or has this child been put under some weird circumstances? And then, of course, commodization of the host, the surrogates. We are creating baby factories, putting up the girls like pigs in a sty and fertilizing them and just creating babies along the way. People have no dignity. People have no informed consent. People have no rights. They're just creating babies to give to people who have money to pay for the intended parents who have money to pay for these surrogates to just give birth. So this is something that should actually be looked into. And of course, exploitation and inequality, especially by agencies. You have no idea the havoc the agencies are creating in this country, Kenya. and in Africa at large, and putting the surrogates at risk. Maybe I should point out that the issue of agencies is one of the reasons why surrogacy was banned for foreigners in India. There used to be a lot of agencies, and they were putting these girls up, you know, in a very inhuman way and exploiting them a lot. And at the end, one of the issues India was grappling with was how to do away with this. And one of the things they said was no commercial surrogacy for foreigners. And they came up with quite a fantastic law. You should look into it about surrogacy. I think it's one of the best surrogacy laws in the world, actually, not in the country, in the world. So you should look at it as well. So what are the recommendations that I would make? Clearly, legal and ethical frameworks. Africa countries individually and collectively needs a legal and ethical framework on surrogacy. There's a lot of ethical issues surrounding commercial surrogacy, and it is only legal and ethical frameworks that are going to cater for this. Price subsidization for the IVF treatment, and of course, price standardization for the surrogate mothers. We should put into place a price that the surrogate mothers cannot go below. In Kenya, we have tried to argue that they shouldn't go below 450,000 Kenya shillings. That's about $4,500. And we should also put into place a standardization where they shouldn't go above, say, $10,000, so that it is not a matter of commercial. You're getting something, yes, out of it. It is semi-commercial per se. You're getting something out of it, yes, but you're not being exploited or otherwise exploiting somebody else. And then we should also look at the eligibility requirements. One of the key things that I keep telling people, which they do not agree with, is we should do away with recruiting surrogates who are illiterate, surrogates who do not have a know-how of the laws. We should do the US way of recruiting people who are financially stable, who are educated, so that to be surrogates. But is that really practical in Africa, where people who do that, as in the people who want to be surrogates, are house girls, saloon girls, and stuff like that? So is it really something that is practical in Africa, or am I just dreaming and thinking, in utopia, wherever? And then sensitization. This will reduce stigma. And once it reduces stigma, then it will avoid issues of agencies putting up these girls in holes and holding them and hiding and putting them in situations that are risky both to their lives and livelihoods, because now people will be aware that surrogacy is something that is widely practiced. It is something that is easy to do. It is something that we do not really have to hide and stuff like that, so that enough people can be able to practice it without any stigma. And also the girls who are coming up as surrogates can actually talk about their own rights and stuff like that. And then, of course, standardized international regulations for reciprocity purposes. We don't know what happens to the children who are born in Africa through a surrogacy program and then transferred to third countries, to other countries. We really don't follow up. It's not like adoption. Adoption, we really follow up on this. But for surrogacy, we don't. We don't know when somebody says, oh, this is their child. Or even when they bring their embryos to your country, we don't even follow up if these are actually their embryos. Perhaps they're just creating children who, I don't even know. They're creating or whatever. Maybe they're even doing some child trafficking along the way, or child sex trafficking, and creating girls and going away with them and, putting them up for that. So we don't have reciprocity rules. We don't have reciprocity laws, and we don't even follow up on what happens to the children that are born out of surrogacy in Africa, either by African parents or by non-African parents. What he mentions, South Africa, the Children Act of 2005 is very, very elaborate on how a surrogacy program should go from start, agreements, everything, from pre-birth order before the child is even created or even transferred, to a post-birth order if that was not happening, to the requirements of the surrogate, 25 years and above. It is very detailed. It is a worthy mention. And it also, most importantly, talks about transferring parental rights from the surrogate to the intended parents. Ghana, the Registration of Births and Deaths Act of 2020, Act 1027, talks about transferring parental rights on registering children born out of the surrogacy agreement. They have not fully discussed about the requirements of surrogacy and that, but just that bit, as in allows a lot of leeway to get into some very good legal framework on surrogacy in Ghana. Kenya, we have Assisted Reproductive Technology Bill 2022. If it is passed as is, it will be a very good law, actually, because it talks about the requirements of a surrogate. It even goes ahead and talks about surrogates getting a medical care and a life insurance before they become surrogates. Unfortunately, the bill, when it comes to transferring of parental rights, it is a little bit shaky. It is not something that I am comfortable with. Uganda has a surrogacy and assisted reproductive technology bill, I think of 2020. It hasn't come into law. However, it has some very good specifications, and if passed as is, it might go a long way into trying to regulate the commercial surrogacy business in Uganda. Egypt, like most Muslim countries, has banned surrogacy, yes, but it is practiced clandestinely. So it's not a worthy mention. I just wanted to mention it to show that there are countries that are practicing this, but under the water, without even planning to regulate it, but they are doing that. So in closing, it is important to realize that as much as the surrogate is what we are talking about commercials. When we talk about commercial surrogacy, our first person that we think about is the surrogate, because we are thinking the girl is being exploited. The girl is coming into this without a surrogacy agreement, without the knowledge of how many embryos are being transferred. We don't know how her prenatal care will go into being. We don't know if she's going to be taken to a specific doctor after that. We don't know how we are going to, after she gives birth. And if she finds out that she's pregnant and perhaps she's carrying triplets, can we do embryo reduction? And if she's religious, can she refuse and say, no, I do not want to do embryo reduction? Because embryo reduction is like an abortion per se. And some people are religious and they do not want to get into the issues of embryo reduction, where you just reduce one sac. Instead of doing a whole abortion, you just reduce one sac by removing one sac and perhaps leaving two, or removing two and leaving one. So we consider, when we talk about commercial surrogacy, we are always considering the surrogate, and rightfully so, because she's the one going through this whole process. We are considering her, health. We are considering her moral aptitude. We are considering all that. Yet we forget this is the only treatment where the end product is a child. At the end of the day, what happens to the child? So it is important that in every surrogacy arrangement, in every surrogacy agreement, the best interest of the child, as enshrined in the United Nations Convention on the Rights of the Child, as enshrined in the African, I can't remember the whole word, but there's the African Charter on the Rights of Children, as enshrined in basic children acts in our countries. Most of our countries, 90% of the African countries have Children Act in their countries, and it enshrines best interest of the children. So it is important that best interest of the children is considered. It is important that the welfare of the resultant child as well is considered. And it is very, very important that the child has a right of knowledge to origin. When I say this, I'm not saying that tell the child he or she was born through surrogacy. I'm saying ensure that the child is genetically related to the intended parents, so that the child has origin. The child can fall back to their ancestry. They know that Ruby is my father, my mother, Ken is my father. Even though I was born through Nora, but Ruby is my mother, Ken is my father. So way forward, let's have legislation. And most importantly, let's have reciprocity. Legislation in Kenya should be able to support the legislation in Uganda. It should be able to support the legislation in Nigeria and in Ghana, because we are doing this not just as individual countries, but as Africa. Let's have legislation and let's have it reciprocated in countries, just not in Africa, but as well outside. Let's have policies and regulations within our fertility centers, within the fertility programs. I have seen someone talking about prenatal care. That is something that even though the legislation will not be able to address, then the policies and regulations in the fertility center will be able to address. This is something that should be discussed before even an agreement is put into place, so that it forms part of the agreement. It says, when so-and-so becomes pregnant, this is the fertility center that is going to take care of the prenatal from day one until birth. or she's going to be sent to a certain hospital under a certain doctor or under a certain medical, medical cover, so that she can be taken care of from the time she's pregnant to the time of delivery. And that is something that should be very straightforward in the agreement and should form part of the policies and regulations of the fertility centers as well. Let's have advocacy. Let's talk about these things. Let's sensitize our people. I am sure, like in Kenya, people are educated, yes. A lot of us are educated, actually. That's the weird part. But people still view things on assisted reproduction as women's things. Let me just say it in Swahili, ini maneno ya wanawake, women's things. So men are not coming up to talk about this. Men are not even advocating for things like this. Men are shunning their women if they cannot carry the pregnancy by themselves, and they're, requiring another uterus to carry for them. So this is something that we need to talk to the men. We need to talk to our governments. We need to talk to the person in the village so that they know this is something that happens and they can do it. They can do it legally. They can do it with a lot of protection. They can do it without being exploited. And it is important to let the girls know that they have a choice. They don't just have to get into this without a choice. They have a choice to get in. They have a choice to get out whenever, wherever they are not safe or do not feel like they need to continue about it. And most importantly, let's network, let's collaborate. This is one of the ways that we are collaborating. We can even have an African database. We can have events and other collaborative seminars and stuff like this. So my body, her body, our baby, that is the end of my session. Thank you.
Thank you so much, Ayeta, for unpacking that. I know it's a lot, but most people are interested in knowing more about surrogacy. Thank you so much. Before I call the next speaker, please allow me to invite Ms. Margaret Kokumu, Registrar, Kenyatta University, to just give us a brief on the importance of academic engagement and to just introduce Kenyatta University School of Law. Ms. Margaret Kokumu. I can't hear on my end. Tuva, are you able to hear Margaret?
Unfortunately not. Margaret, could you try again?
She could be having trouble with her mic.
Agreed.
Okay. Margaret, please allow us to come back to you as you try and fix your mic because we can't hear you on this end. As Margaret fixes her mic, please allow me to introduce Dr. Olanike Adelakun, Associate Professor, Faculty of Law, Lead City University based in Nigeria. Dr. Olanike is going to speak about the regulation of cross-border surrogacy and the efforts of the Hague Conference on Private International Law in Africa, and just unpack the dilemma of uniform regulation and the intervention or attempt of the international social services which led to the Verona Principles. Dr. Ayeta, welcome. Sorry, Dr. Olanike.
Thank you so much, Elizabeth. I'm trying to share my screen now. Okay, thank you so much. So I'll be talking about attempts to regulate cross-border surrogacy arrangements in Africa, globally, and then we'll bring it down to Africa. So I like the fact that Ayeta has really laid a very good foundation for this discussion, and especially as it has to do with attempts across Africa to regulate surrogacy. So basically, I'll touch on relevant instruments at the global, regional levels and the intervention of the Hague Convention on Private International Law. Then I'll talk about the initiative of the international social services that give birth to the Verona Principles. So without wasting much of our time, I'll just look at the international legal framework and initiatives of the United Nations. So I try to look at what laws are, the provisions that indirectly related to reproductive health rights. And then I'll key it down to surrogacy or the right to reproductive health. So if you look at the UDHR, I always argue that there is no way you talk about some so-called socioeconomic rights without talking about key fundamental rights. Because if you look at it strictly, it's tied to each other and you cannot enjoy one without having access to the other. So if you look at the Universal Declaration of Human Rights, we have the right to life, we have the right to equality and freedom from discrimination, we have the right to privacy, we have the right to family, the right to health, education, and to benefit from scientific advancement. And you may start wondering what exactly is the correlation of these rights to assisted reproductive technologies and then surrogacy. If you look at the right to life, yes, we can argue that everybody have a right to life. And if you look at your reproductive health rights, in a way, it is linked to your right to life, especially when we start talking about maternal mortality. And as Ayeta says, putting surrogate mothers through some hormonal treatments, implanting multiple embryos in them without their consent and without adequate knowledge on how to manage the consequences actually threatens their life. And not just their lives, even the lives of the embryos itself. So when we look at the right to equality and freedom from discrimination, I love the fact that Ayeta argued that should we move towards ensuring that surrogate mothers are educated? And this brings us back to the issue of exploitation, commercialization. If there, like, it depends on where you are looking at it from, or the perspective. Because I always argue that if these people that are putting themselves up as surrogate mothers have the economic capacity to survive or to meet their financial needs, would they have gone into that commercial surrogacy in the first place? And to me, if the answer is no, then I would say it is not true consent to actually act as a surrogate mother. So if there is no discrimination, we shouldn't have issues where people from richer countries come to places like Africa, like Asia, to seek cheaper options for surrogate motherhood, especially when those that are putting themselves or when those that are being recruited by the agencies are not well informed about their rights, about the complications, about the postnatal depression or illness that may follow the process, about the hormonal challenges. Then it brings a question about discrimination and equality, and yes, reproductive justice. Then when we talk about right to privacy, yes, Ayeta also mentioned the fact that there are so many important information that are not supposed to be out there. They are not supposed to be released anyhow, especially without the consent of the parties involved, but that find their way all about. And this, in a way, breaches the privacy of those involved in surrogate motherhood arrangements. Then the reproductive health right is also tied to the right to marry and found a family. And like we know in Africa, it's not just about getting married and starting your own family. It goes deep to the extent that there's an expectation, there's a societal expectation that you are to conceive, you are to have children. So what happens in situations where you are unable to have children? That is another thing we need to examine. Then right to health. Yes, when we talk about right to health, the popular perception is that, oh, you have malaria, you have cholera, you have this, you should be able to have access to treatment. But what about infertility? At what point do we start seeing infertility as a health challenge in Africa? Yes, I know we talk a lot about reproductive health rights, but the focus, especially from the output of the ICPD, had always been on access to contraceptives, access to family planning. which is still targeted at population reduction. What about access to assisted reproductive technologies, or access to support in conceiving when the couples or the person involved is infertile? So then right to education, yes, when we talk about information, you have the right to be informed, not just the Western education, not just the education in the formal sense of it, but education in the sense of having access to information on reproductive health services and assisted reproductive technologies. Now we have the right to benefit from scientific advancement. We know assisted reproductive technologies are an output of medical advancement. And should this be a fundamental human right, and do people actually have access to benefit from it? This still brings us down to the issue of reproductive justice. Can an average person that cannot afford the treatment of ART walk into a clinic and say, this is my talent and this is what I need? And if you look at the ICCPR, there are similar provisions, and it's still based on the same argument, so I won't waste much time on that. Then we look at the International Covenant on the Economic, Social, and Cultural Rights. It also gives us protection to the family. There's a provision on right to health, education, and also right to benefit from scientific advancement, which still talks about things like assisted reproductive technologies. Then for the first time, we have a convention that is focused on eliminating discrimination against women. That is the CEDAW, and it focuses more on right to equality, right to equal treatment, equal access to healthcare, discrimination, right to be free from discrimination in all family matters. And this involves having equal rights in marriage, giving consent in marriage, having a say on your health and everything, and specifically being free from sexual and gender-based violence. So we also have the Convention on the Rights of the Child, which specifically protects the child from discrimination, from right to life. We have the right to life, health, education. And in terms of education, yes, I will still hinge it on sexual and reproductive health education as well. And then when we talk about freedom from discrimination, even though surrogacy is still an emerging discourse, we already see instances where children born out of surrogate motherhood arrangement are already being discriminated against, as opposed to the other children, as opposed to their counterparts who did not come to the world through assisted reproductive technologies. So how does this also affect the right of the children born out of these arrangements? Then we have the ICPD Program of Action, which actually focuses more on reproductive rights. And for the first time, there was an emphasis on reproductive rights and reproductive health. And specifically, Chapter 7 dealt with reproductive rights and reproductive health. Unfortunately, this is still more focused on, like I said, access to contraceptives and family planning, which is still more about population reduction. But there is we did not have much emphasis on support for those that are actually infertile or that may not be able to carry pregnancy to term, thereby necessitating the need to use a surrogate mother. So in Africa, yes, we have the African Charter on the rights of African Charter on the Human and People's Rights. And yes, it has similar provisions to the UDHR and other conventions at the global level. We have the right to equality, information, education, health, family, freedom from discrimination, and yes, right to development. And there have been a lot of discussion on what development means, in what context do we use it. But for me, I would say, yes, we still have similar things. Unfortunately, there is no right to reproductive health in the African Charter as well. And then we have the African Charter on the Rights and Welfare of the Child, which also has similar provisions. And more interestingly, we have the Maputo Protocol. That's a protocol on the rights of women to the African Charter. And it also provides specifically for more direct rights for women. And interestingly, we have the right to reproductive health, which gives a woman the right to choose when, how, and where to have children, the spacing of their children. But a critical look at that provision on reproductive health of the Maputo Protocol is similar to what we have in the ICPD, which is still on access to contraceptives, to family planning. But yes, it can be argued that it should not be interpreted in a restrictive manner, but the right to reproductive health expands beyond contraceptives or family planning, but goes way up to fertility care, especially for those that do not have the means to afford assisted reproductive technologies. So in a way, I believe right to have your own family and the right to reproductive health right are key rights which can actually be used to argue the right to assisted reproductive technologies within the context of reproductive health rights. And due to the complexity of the discourse of assisted reproductive technologies, and specifically surrogacy, the Hague Convention on Private International Law launched some programs, research, and to come up with something to regulate cross-border surrogacy because of the complexities that were emerging from these arrangements. And before 2010, efforts were made to actually see if the Hague Convention on Intercountry Adoption can be used to regulate cross-border surrogacy arrangement. But of course, there were issues, especially when the surrogacy arrangement was entered into in a country that does not permit intercountry adoption, and you have to take that child to a country that permits intercountry adoption, then it becomes a problem of adoptability. Like, is the child eligible for adoption? And in the absence of that, then it is not possible to have your surrogacy in one country and rely on the intercountry adoption convention to take that child to your own country. So it became practically impossible to adapt the Convention on Intercountry Adoption to regulate cross-border surrogacy. So this necessitated the project to see how international surrogacy arrangement can be regulated, or how issues emanating from these arrangements can be managed in a way that protects the rights of the parties, and especially the legal parentage of the resulting child or the intending child. So as a result of these, questionnaires were thrown out to stakeholders in different countries, and it was made freely available online. And by 2015, there was an expert group that was inaugurated to look into this, so they could come up with the appropriate convention or instrument to regulate cross-border surrogacy arrangements. And this group started meeting in 2016, and they kept on meeting. I don't want to go into details, but one thing that really emerged from all those meetings is that it is practically impossible to have a convention on cross-border surrogacy arrangements. That is because of the different stance that different countries take on surrogacy. And some of the issues are, do we abolish, do we prohibit commercial surrogacy? Do we make it just altruistic? Is it possible to have cross-border surrogacy agreement and have a uniform approach to regulate this? And when all these questions were raised, it became practically impossible to have a uniform approach to regulating surrogacy all over the world. As a result of this, the expert group came to a conclusion that they cannot come up with an instrument to regulate cross-border surrogacy. Rather, the focus should be on dealing with issues that arises out of cross-border surrogacy arrangement, such as a legal parentage, such as enforcement of, such as recognition of legal parentage of the children, such as statelessness of the children born out of this arrangement, such as protection from exploitation, and all those stuff. So as a result of that, the proposal or the recommendations basically were on how to recognize foreign judicial decisions on legal parentage and coming up with an instrument on legal parentage, and specifically probably a protocol on legal parentage of children born out of surrogacy arrangement. And like I always say, I have my reservations about that, because if you are saying you are making a recommendation that the HCCH should work on an instrument on legal parentage and enforce and recognition of judicial decisions on legal parentage, and then you still made a recommendation on having a protocol on legal parentage of children born out of cross-border surrogacy arrangement. To me, that is in itself a discriminatory recommendation, because now we are saying the children born out of cross-border surrogacy arrangement are different from children born out of other arrangements, which means you want to have a separate protocol to regulate their home legal parentage, rather than incorporate them in the main instrument that seeks to regulate the parentage, the legal parentage of children born in international settings. To me, it's something that can actually be done in a single convention without necessarily emphasizing the circumstances surrounding the birth of children that were born out of international surrogacy arrangements. So in 2023, a working group was also developed. A working group was inaugurated to actually come up with a draft instrument on the recommendations of the expert groups, that is a convention on legal parentage and possibly a protocol on legal parentage of children born out of surrogacy arrangement. So as at April this year, the working group have discussed the content of the provisions of the draft instrument, and they are still working on producing a draft instrument. So on the part of the HCCH, which is like one of the bodies that have worked so far directly on how to deal with issues that have to do with legal parentage in surrogacy, have done so far. Hopefully by end of this year or by first quarter of next year, we hope the working group will be able to come up with a draft provisions or draft instrument, which would form a basis for another discussion. And then we have the intervention of the International Social Service. They came up with what they call the Verona Principles. And these principles was born out of a discourse by over 100 experts of diverse backgrounds from different nationalities, from different regions, and to look at how we can actually guide national parliaments on developing regulations for surrogacy, both internationally and within their domestic sphere. So what they did was to come up with what they call the Verona Principles, and the principles are supposed to be a guidelines for nations that wants to develop a legislation on surrogacy, and it focuses strictly on the children born through surrogacy arrangement. So the idea is to look at the rights involved, how to protect the rights of these children, the right of the garment donors, the right of the surrogate mothers, the legal parentage, the rights and responsibilities of parents, the financial matters, intermediaries. So what the principles does is just to try to cover instances, what to pay attention to, the rights and the nature of the rights that are involved, and how to actually make sure they are catered for in any domestic legislation that countries may want to go into. However, even the Verona Principles and all previous initiatives at this level, I decided not to go into countries' initiatives in Africa, but I'm aware that the East African region have come up with a draft instrument, which is still a draft, which actually guided the countries of the Eastern region like Kenya, Uganda, Malawi, to come up with their own bills in their countries. And for me, that is still like the most progressive initiative that we've seen on the continent so far. I think coming together at the Eastern African region has sparked the countries of the Eastern region to at least develop bills to, even though none has been passed into law, we still see that this is a great initiative that is sparking national governments to discuss this. And then in South Africa, we know South Africa has a law, Chapter 19 of their Children's Act, that specifically covers surrogacy. As beautiful as the law is, there is still a gap on international surrogacy arrangement. So it focuses more on domestic surrogacy arrangements where parties are domiciled in South Africa, they have South African nationality or domicile. But there is a gap as to what happens if South Africans go outside South Africa to engage in surrogacy, probably commercial surrogacy. Would that be recognized in South Africa? Or if the surrogate mother was engaged in another country and then the implantation took place in another country, the law of the Children's Act did not cover instances like that. And then, yes, we know in South Africa, it's only altruistic surrogacy that is permitted and not commercial surrogacy. I know in Nigeria, we had a bill which lapsed in 2019. Unfortunately, it was not passed into law. And the bill, I guess it was not passed into law because there was a lot of loopholes. It was more of an imported bill of the ART bill of India in 2014, which was also not passed to law in India then. And I know in Ghana, they also had a bill which lapsed, which was not passed into law. So, but apart from the Eastern African region, we've not had this kind of unification in other regions, in other sub-regions in Africa to come together to develop an instrument or a guide instrument to guide national countries, to guide nations on how to go about developing the various laws. And yes, the issue of capacity is something to look at. Do we actually have the capacity to deal with this? And if not, what are we doing to make sure we bring experts together to at least guide the lawmakers on how to go about this? And like I said, we have some gaps in ongoing initiatives. I think so far, most of the bills and the laws that I've read, even at the international level, try to avoid the issue of abortion, whether voluntary or selective reduction, especially when it has to do with commercial surrogacy. And they leave this to the whims of the parties to incorporate into their various contracts. We know this is at the detriment of the surrogate mother. If you do not have an express provision on abortion, unfortunately, it becomes complicated when you're trying to come up with a surrogacy law in the country which prohibits abortion or which criminalizes abortion. For instance, I know a lot of West African countries have a law prohibiting and criminalizing abortion, yet surrogacy is being carried on en masse in the countries. So how do we deal with this? How do we deal with issues where there are so many unethical practices? You implant like 4 or 5 embryos into a woman, and let me say, unfortunately, maybe 4 germinate and become fetuses. How do you go about selective reduction without necessarily saying this is like a violation of the law on abortion? How do we go about the surrogate woman, mother saying, I do not want to carry this pregnancy again. I want to abort this pregnancy at this point. Does she have the right without standing the risk of going to jail for the action? Then we still have issues on how to go. We still have challenges, gaps on direct provision on how to deal with international cross-border surrogacy, especially in the aspect of reproductive justice. Then we now have a new trend that is the use of artificial intelligence in embryo selection, formation, and treatment. For the treatment, I don't have a problem. But when we have to start saying we are using AI to determine which embryo is perfect for the needs of the commissioning parents, which now gives rise to ethical issues on designer babies. I want a baby girl with long hair, dark skin, blue eyes, and I say, okay, we need to use artificial intelligence to profile the information of the donors in order to match the specific embryo with my needs. Is that ethically right? So I think these are issues that must be taken into consideration. in any law that we try to look at. Then we have the question of genetic link, which is an issue that has really generated a lot of discourse, especially in places like South Africa. Should the laws take this into consideration? Should there be a genetic connection between the commissioning parents and the child? Or should they be permitted to use donor gametes all through? Especially when we see foreigners coming to the continent to come and to commission surrogacy. And when we, even when they come, it's still better. We now have issues. We have instances where the agencies just import the embryos and then they perfect all these things and just implant without the commissioning parents even stepping their foot in Africa until the child is born. So these are issues we should look at. How do we ascertain whether they're actually genetically related to those that sent the gametes down to Africa? So, and then, like I said, capacity awareness. We need to create more awareness, especially in communities that are being targeted for recruitment of surrogate mothers. We need to create awareness on the rights, on how this is done, on what to pay attention to, especially in the formation of the contract, in the essence of being aware of what they are signing, of what they are getting into, and on the aspects of informed consent. It's not just about getting that consent, but how informed is that consent? And to what extent do we now validate this consent if we find out it is not informed? So thank you so much.
Thank you so much, Dr. Olanike, for taking us through the frameworks. Right now, we'll go into a Q&A session, and I see we have around 4 questions on the chat. So I'll just read the first one. So in case you have any questions, please lift your hand and my colleague Tuva will be able to unmute you. So I think this goes to Ayeta. Do we have documented psychosocial experiences of surrogates in Kenya, Africa? Let's see.
Can I answer it?
Yes, please.
Yeah. Currently, we don't have a specific documented research on psychosocial issues on surrogates in Kenya because we don't even have a legal profile for it. But what we have tried to do as the doctor just spoken before me said, East Africa, we have gone a step ahead in trying to, come up with our own rules and regulations and stuff like that. So one of the key requirements that we actually need for parties before they become surrogates is to have a psychological analysis. They must be psychologically analyzed by a clinical psychologist and then done through counseling. And then after delivery, they are also required to go through psychosocial counseling to enable them detach from wherever there is. There's one that I had answered. I hope that I've answered, but there's one that I had answered there, which had asked if there's any country that usually you can have surrogacy without having a medical condition. Yes, in US, you can have surrogacy without having a medical condition as long as it is usual in some states, not all states. In some states, as long as it is something that is state-oriented. You see, even that, there's still discrimination. Say you are in active military care or active military operation, then you can go ahead, or you're doing something for the state, then you can go ahead and have surrogacy without a medical condition. So on psychosocial services, we don't have documented, unless maybe we start doing that, bearing in mind that the first surrogate babies actually in Kenya at the moment are about 16 years old. The first IVF babies in Kenya are 18 years old. So it is something that we really need to find out. These people who are giving birth 16 years ago to surrogate babies, how are they doing psychosocially and stuff like that? Thank you.
Thank you so much. I think for the next question, I'll probably ask the both of you to respond, but he's asking, from all your research to date, what formal and substantive requirements have you identified for the conclusion of the contract between the surrogate mother and the child's real mother? And is this contract executed in good faith, for example, in the event of the surrogate mother giving birth to a still child further what happens if the child's real parents who are still fetus die before the child is born? It's the first question. Should I read the other one before you respond to that?
Sure.
Okay. So the second question, what happens if during the execution of this contract, the surrogate mother wants to unilaterally terminate it? Does this give her the right to an abortion? Yes, Dr. Olanike raised her hand. You can proceed.
Okay, thank you so much. Like we discussed, and I know Ayeta also dwelt a bit on this, it is so unfortunate that in the absence of regulation, we cannot really say what the substantive nature of a surrogacy contract will be. So it is left to the parties to determine what terms and conditions go into the contract. And unfortunately, when we look at the profile of the surrogate mothers across Africa, they are mostly illiterate. That except maybe in places like Nigeria and Ghana, that you have graduates going into it. And empirical research has shown that even those that are educated that go into it in this part of the continent do so because of the motivation of the financial payment. So in the absence of financial benefit, they always say they will not act as surrogate. So which means it still comes down to the economic benefit that they stand to derive. And in most cases, they only focus on this is what I'm being paid. And they don't really focus on the terms and conditions of the contract. And a lot of them do not even understand the legal language in which these contracts are prepared. And for those that are not even educated enough to read the contract, is that there's no proof that they actually have a literature in the contract that makes them to understand the nature of the contract. And like I said, informed consent is very important. Even for those educated surrogate mothers, how informed is the kind of consent they give? Do they actually disclose the full details of the treatment, of the consequences, of the complications that may arise? And the fact that they are not even permitted to give birth naturally, it has to be through cesarean section. Do they give full disclosure of the complications that may arise? In most cases, the answer is no. And most times they would have signed the contract, the embryos would have been implanted before they start seeing the side effect or the consequences of this treatment or the complications that arise. And when they try to opt out, they always say, you are bound by your contract, you cannot opt out. And like I said, in most cases, the moment conception is achieved, the surrogate mothers are not permitted to opt out. Except if you look at the laws in South Africa that permit such a surrogate mother to opt out, provided she's genetically related to the child. That is, for those that are gestational carriers, yes, they can still opt out by terminating the pregnancy, but they must inform the commissioning parents. But in most other African countries that do not have regulation, it is just based on the terms of the contract. And the surrogacy agencies in most situations draft this contract to favor the commissioning parents and at the detriment of the surrogate mothers. Unfortunately, a surrogate mother that is into a contract for the financial benefit in most situations cannot even afford the services of a legal practitioner to look at the contract and advise on our rights or not. So it's so unfortunate that we are just bound by the terms of the contract that we signed. Thank you. I hope that answers both questions.
Thank you, Dr. Olanike. Ayeta, you want to add something?
Yes, just to add on what Doctor has said, though she has covered most of it, I just want to answer the part of what happens when the real parents, the intended parents, die. We have had such a situation in Kenya, unfortunately, where parents commissioned for a surrogate. And once the surrogate became pregnant and almost giving birth, these parties were Kenyan but living in abroad. So they had already gone back to their country and they had come back to Kenya briefly to take their children. So by the time they were being informed, the intended mother was being informed that the surrogate has gone into emergency labor, and she traveled from her village coming to Nairobi. She got an accident and died on the spot. And they had not being something that is private and all that, they had not told their people and stuff like that. So such issues actually make you now have other situations in place. So right now, every contract has to have a guardian ad litem mentioned in the agreement, such that whatever happens, if something happens to the intended parents, then this guardian ad litem is the one who is charged with the duty and responsibility of taking the children or child immediately at birth. This helped during the COVID era, where parents were locked out in other countries and counties, and their surrogates are giving birth, say, in Nairobi or Mombasa. And it also helps in issues where intended parents come and they're all lovey-dovey, they're doing the program, and then they decide they're divorcing, or they decide, especially the reason why I keep insisting there has to be a genetic link. Once they divorce and maybe they used a gamete donor, maybe egg donor, sperm donor, and they decide they really don't want the children anymore, and the surrogate is stuck with the child, or the children's home takes the child, then the guardian ad litem is the one that is charged with taking the duty. Unfortunately, some parents just give you the guardian ad litem's name, and when you're doing the agreement, you are not able to verify who this guardian ad litem is, and that is why we need some frameworks where we can actually take these agreements, like in South Africa, to court first before treatment starts, so that this guardian ad litem becomes liable throughout. Thank you.
Thank you so much, Ayeta. Interesting facts coming out. So we have a specific question for Dr. Lanit K from Daniel Mihiga from DRC. And he's asking, he'd like to know, given that there's a kind of legal vacuum on the issue of surrogate mothers, if such a case is raised before the judge of the Africa court, what would be the legal address to which he could refer to?
Thank you so much. I think the first point will always be to look at the contract law of the country in question and see if a contract can be challenged on the public policy principle. If that is possible, then that is a point to actually challenge the contract itself. Then another one is to hinge on the rights involved, the rights of the woman, the rights of the child, the reproductive health rights, the rights to be free from discrimination. So like I said, and like I pointed out, in all those instruments that provide for fundamental rights that hinge to this right. So the argument will always be to hinge on the rights of the particular person that you are trying to advocate for. If it's to advocate for the reproductive health rights, the right to conceive, the right to form a family, then you want to hinge your argument on that. If it's to protect the surrogate mother's right, you want to hinge on the right to equality, the reproductive health right to choose when, how, and when not to have children. So I think we can just use every other fundamental right that are guaranteed in all these instruments to argue whatever we are presenting before the African court, and then leave it to them to decide. So I guess that is the best shot that we can have for now. Thank you.
Thank you.
Can I
Thank
just
you.
add something?
Yes, please, Ayeta.
A lot of cases actually on surrogacy have been decided worldwide and in Africa. Like in Kenya, we've had almost 5 to 6 cases decided, leave alone the many cases that go to the Children's Court on a monthly basis for parentage and parental rights. However, what I have noted when the magistrates and judges are deciding this, one of the key things that they do is follow the best interest of the child. At the end of the day, what is right for the child? And to determine this, some of the things they look into is, where are the gametes coming from? Are they for the intended parents? Are they for the surrogate? Are they for donors? You see, how they decide for if the gametes are for the donors or for the intended parents or for the surrogate, then it differs party to party. And then also another thing is, was the agreement before or after the fact? Because if you're going to get into the agreement after the fact, clearly there was no informed consent. The surrogate can argue that this is my child, you have donated to me sperm and egg, or you have donated to me an embryo, and she can rightfully keep the child because she is the birth mother. So if an agreement is done before the fact, it bears more weight than, say, an agreement that has been done after the fact. And that is why in all third-party reproduction, it is important to do an agreement before the fact. Most importantly, they always determine the intention behind the whole process. What was your intention? Were you trying to create a family? Was this something that you came together to create a family and stuff like that? So with that, and looking at all the laws that doctor has said, then the magistrates or the judges worldwide have been able to decide on a lot of surrogacy cases. Thank you.
Thank you so much, Kenyatta. I'm going to combine these two questions. They're close to each other. So if a child born of a surrogate mother realizes that she was born of a surrogate mother, can she later decide to seek out her real parents and change her surname? And the other question is, will the child born of a surrogate mother be informed later that he or she was born of a surrogate mother, or will this be kept a secret? Yes, Dr. Olanike, please go ahead.
Thank you so much. This is one of the ethical issues, again, that arises. You see some laws permit that the child should have right to information on the medical information about the donors and the carrier at the age of 18. And you have some laws across the globe, like the UK now has abolished anonymous donation, so the information of the donors must be kept. And I think in Africa, considering the social expectations on conception, the practice in most cases is to hide. Even we see instances where adopted children, the fact that adopted children are kept secret from them. And then we now say, there is no law that actually regulates that the children should have a right to information on the circumstances of their birth. So, but can we now, that is another thing we have to argue in the light of the right of the child to information. Should that child have the right to know that he or she was conceived as a result of surrogacy arrangement or not? I think we may have to also look at emerging discourse on this across the globe. Like I know in some European countries, it's now mandated to disclose the identity of the donors. And that is why you see some people going about the internet saying they want to connect with their biological father, those that donated their garments to them. So whether the child should have a right to know the circumstances of their birth is something that is still emerging, especially in conservative places like Africa. So I think this is another thing we really have to look at when developing model laws. Thank you.
Thank you, Dr. Olanike. So the last question on the chart, Samina would like to understand about surrogacy insurance. Is it compulsory to take out medical insurance for the parents? Yes, Ayeta. Please proceed.
Ideally, we should be taking out medical, not just medical, but medical and life insurance for the surrogate, just in case anything happens. However, there are a lot of, this also matters from country to country. Countries will, and also insurance agencies, because a lot of insurance agencies are not like in Kenya, they're not giving you insurance if you're going to give birth in the next 1 year. You have to be on insurance cover for a while before. So this is something that you have to plan long-term before you do that. Yes, we should be taking out insurance covers for medical insurance cover. And yes, we should be taking out life insurance in case something happens to the gestational surrogate, then whatever her children can benefit from it. Bearing in mind, surrogates are supposed to have had at least one live birth, and they should have at least one living child. So in case something happens to her, or she dies in the process, or becomes medically incapacitated, then this insurance would be taking care of it. Kenya, we don't have an insurance cover that covers that. However, in most African countries don't have insurance covers that covers surrogates, but unless you just take out a medical insurance cover. But most first world countries actually have medical covers and life insurance covers for the surrogates. Thank you.
Thank you, Ayeta. Tufa, do we have any hands up or anyone requesting to
No.
ask their question?
Not at the moment.
Okay, I think so far we've exhausted the questions on the chat. We're going to take a 7 minutes break just for us to stretch, get some coffee. Please don't log out of your computer. I'll put some jazz music, and once it stops, please come back to the webinar. There's a question that has just been put on the chat. I don't know if we can respond to that before we take a break. Yeah, let me just, we could just respond to this one before. So what happens if during the execution of this contract, the surrogate mother wants to unilaterally terminate it? Does this give her the right to an abortion? Yes, Ayeta.
Once pregnancy, you can terminate a contract anytime before pregnancy is achieved. Once pregnancy has been achieved, then unfortunately, the surrogate cannot be able to terminate this, because now that means that she has to go through an abortion process. And as Dr. Olanike said, a lot of African countries do not have abortion, they do not support abortion. So it is possible to terminate a contract before a pregnancy is achieved. And once a pregnancy is achieved, then the surrogate has to bear the child, has to carry the child until it is conceived, unless in the medical expertise of her doctor, it is necessary for a termination to occur. But once a pregnancy has been achieved, then the surrogate cannot terminate the process.
Thank you, Ayeta. Interesting insights. So with that, we'll take a 7 minutes break. Please let's resume at 13:10 East Africa time. Please don't log off. See you in 7 minutes. Thanks.
She is not. Ryan, est-ce que vous êtes là, Ryan?
Oui, je suis là. Je suis là.
Merci. C'est la même question pour vous. If you can tell us how you got to know about the AGEMCC, what was your experience participating in the AGEMCC, and what did you gain from your participation?
Ok, merci beaucoup pour la question. J'espère que vous m'entendez très bien.
Oui, oui, continuez s'il vous plaît.
Merci. Alors, la manière dont j'ai connu ce concours, c'était vraiment d'une manière vraiment exceptionnelle parce qu'au départ, j'étais déjà hors délai. J'étais déjà hors délai dans la participation. Et donc, il y avait déjà d'autres camarades d'autres universités congolaises qui participaient. Et au regard du fait qu'ils me connaissaient, du fait d'avoir participé à un concours similaire au Caire plutôt, organisé par le Center for Human Rights de l'Université de Pretoria, alors ils m'ont contacté pour les aider. Et c'est une semaine après, après avoir lu le cas hypothétique, que finalement, je me suis rendu compte qu'Equality Now a décidé de relancer la candidature vu qu'il n'y avait pas encore beaucoup de participants francophones. Et c'est ainsi que notre université a eu à participer. Et donc, en réalité, j'ai, j'ai eu vent de ce concours à travers d'autres participants que je devrais en principe aider et par la suite avec lesquels j'ai dû co-participer. D'ailleurs, je les avais affrontés dans la phase en ligne pour le compte de la République démocratique du Congo. Et donc, c'est ainsi que j'ai eu vraiment vent de ce concours. Et puis par la suite, aujourd'hui, j'en ai vent partout ailleurs parce que je suis déjà en lien avec Equality Now, que ce soit sur mon mail, que ce soit sur LinkedIn, etc. Et voilà ça en général. Et c'est un peu un appel aussi aux étudiants, aux différents participants, à tout le monde, de toujours, voilà, on a les nouvelles technologies, mais il faut savoir bien les utiliser aussi, parce que c'est bien, on peut être là juste pour ce qui est comme distraction, mais c'est aussi très bien de pouvoir savoir mélanger ce qui est utile à ce qui est agréable, et ce qui est utile certainement, c'est avoir ce type d'opportunité que Equality Now met à la disposition des étudiants et de divers participants, et c'est ainsi que l'on peut, tout le monde peut savoir prendre et tenir ce type d'opportunités qui sont offertes. Alors, en ce qui concerne mon expérience personnelle, elle a été très riche, extrêmement riche d'ailleurs, plus riche que ce que je pensais, parce que déjà, on commence par une phase en ligne, telle que cela a été explicité bien avant. Et la phase en ligne, elle a été assez particulière, je peux le dire comme ça, au regard de temps à autre de certains défis, que ce soit généralement sur la connexion, Même au départ, d'ailleurs, avec certaines universités, on commence la participation et certains pensent que c'est une blague à dire que vous avez commencé quelque chose en ligne, mais comment ça va se réaliser, etc. Mais au final, on se rend compte qu'en réalité, c'est quelque chose de matériel. Peut-être là maintenant, il n'y a pas des participants qui ont dû voir nos phases en ligne, mais on était quasiment seuls, on n'était pas du tout soutenus. C'était moi et mon camarade qui avons d'ailleurs arrangé tout en ce qui concerne la connexion. Mais au final, c'est devenu du sérieux. Et, euh, et en soi, après cette phase et en arrivant directement au Kenya, personnellement, j'aimerais remercier directement Equality Now et toute l'équipe organisatrice parce qu'on a été très bien accueillis, très très bien accueillis, que ce soit là où on faisait le concours en présentiel, que ce soit là où on logeait. C'était vraiment du très haut niveau et de la bonne qualité. Et surtout, ça nous a permis, et c'est là que peut-être j'invite aussi les camarades, ça nous a permis à pouvoir non seulement agrandir notre réseautage avec divers professionnels de droit international, d'abord de un, de droit international des droits de l'homme de 2, et des praticiens, ça c'est très important. Et puis en deuxième position, notre réseautage aussi à notre niveau des étudiants ou bien des personnes de la même génération que nous, que ce soit d'autres personnes qui ont d'autres manières de voir le monde, de voir les choses, de vivre le droit. Et ça, c'est extrêmement important, en tout cas pour moi. Et je remercie, je préfère vraiment profiter de cette occasion pour remercier Paulina et toute l'organisation. Alors, en termes d'expérience personnelle, j'aimerais le dire ici, il y a déjà des thèmes qui sont très importants et qui sont ici abordés par Ecolina et par ce concours en matière de procès simulés sur l'égalité des sexes. Ça, c'est de un. Mais en deuxième position, et là, c'est plus particulier, c'est qu'il y a des thèmes qui sont vraiment choisis. Et au départ, on peut peut-être les banaliser. Bon, nous, pas particulièrement, on a eu à plaider autour du principe de non-discrimination par rapport à une pratique discriminatoire dans une coutume. Et aujourd'hui, c'est quelque chose de très vécu, extrêmement vécu dans plusieurs coutumes au niveau africain, pour plusieurs raisons d'ailleurs. Et pour ce thème qui a été choisi pour cette année, c'est vraiment très particulier, c'est vraiment très excitant, certainement. Ça va être très intéressant pour tous les participants. En tout cas, j'envie même, j'aurais aimé participer aussi. Et puis, il y a un bon panel d'experts pour aussi exploiter toute la question. Et donc, ça sera une expérience riche, surtout en connaissances d'abord, une pratique riche en pratique, bien sûr, euh, une pratique riche aussi en termes de réseautage, en termes de personnes rencontrées, en termes de connaissances acquises, mais surtout, surtout en termes de vulgarisation. Aujourd'hui, le protocole de Maputo, il est là. Il a déjà plus de 20 ans, beaucoup plus d'âge que certains universitaires peut-être, mais beaucoup de gens l'ignorent. Ils ne savent même pas de quoi il s'agit. Et je pense que progressivement, aujourd'hui, Coalition permet à ce que, au niveau africain, plusieurs personnes deviennent de plus en plus informées de la question, plusieurs personnes deviennent de plus en plus intéressées. C'est comme une famille Equality Now, une famille du genre. Et j'espère que cette lutte continuera à être menée du jour le jour et par ceux qui ont pu participer à ce type de séance et à ceux qui auront à participer au concours en présentiel. Et je suis sûr que ça pourrait être une belle expérience pour eux, tel que pour moi, ça l'a été vraiment très riche. Et aujourd'hui, je deviens comme un témoignage vivant et parlant de cette expérience, de cette riche expérience. Et je suis très fier encore une fois de participer aujourd'hui. S'il y a des questions, je suis toujours là pour là.
D'accord. D'accord. Merci
Donc,
beaucoup,
merci beaucoup.
Ryan. J'ai le question après. Mais pour maintenant, c'est pour Nadia. Nadia, if you could please tell us what your experience has been with your participation at the last AGEMCC, and maybe also tell us how did your participation influence your work at the university and what you're currently doing.
All right. Good afternoon, or it's afternoon where I am. I think it's afternoon there as well. My name is Nadia Mutisi. I participated in the AGEMCC last year with my Moot partner, Claudio Faro. Firstly, I think I've always been a women's rights activist. I think it's something that's always been very important to me from far back. So I did a lot of volunteering in university, and I think the Moot competition was one way that I could see how the law can help. I think in a lot of ways, when you are an activist, it almost seems very philosophical. And sometimes it just seems as if there is no practicality to the things that you will be asking for, the asks that you have. So I think for me, the Moot competition gave me insight into how we are able to practically provide or practically be able to influence policy within our different countries and nations. Before I did the Moot competition, I had worked at a think tank where one of my mentors told me about the Maputo Protocol. And she spoke about how the Maputo Protocol was the first instrument in the world to provide for the right for women to be able to abort, or the right to abortion, which I found very interesting. And it was nice because this was happening in the United States, for someone who's not even African to tell me about an instrument that is actually African. What I loved about the Moot Court was that this was the first time that someone was saying, let's own the Maputo Protocol, which we should be very proud of because it's a very progressive piece of legislation that looks at the rights of women. So the Moot competition allowed me to see how lawyers can contribute to human rights access, and how lawyers can also contribute to the rights of women, essentially. I think when we look at gender equality, issues of gender equality, sometimes they can seem very far removed from the work of lawyers. I also think that it gave me insight into how legislation from around the world speaks into one another. So one of the questions I remember being asked was the due diligence principle, which was the case of Velasquez Rodriguez versus the state of Honduras. And sometimes I think we don't realize that laws borrow from each other in such a way. So I was very grateful to be able to go through a process that showed me practically what international law is and how international law ought to be utilized. So I think it has to be that issue of practicality, that there are things that lawyers are able to do on a daily basis, that lawyers are also able to engage in strategic litigation and actually have outcomes that are useful. It revived to me the African Court on Human and People's Rights. I think sometimes these kinds of entities exist almost in an idealistic kind of perspective, especially because they're very difficult for normal people to access. But when young people are brought in a space and they're told, pretend you are arguing before the African Court on Human and People's Rights, it kind of gives you a space to envision as well what your contribution will be. So I think the Moot Court competition helped me to stop seeing myself in terms of borders, but to start seeing that my work does not necessarily have to be limited to Zimbabwe, but my work can also speak into how other people in other countries are, relating to the legislation and relating to aspects of gender equality. As a winner as well, I was given an opportunity to undertake an internship, which by the time that the offer came, I was already engaged somewhere else. So I couldn't take it up, but I think it helped in terms of my mental health, because at that time, a lot of people were looking for jobs. And I had that offer that I had, which really made it much easier for me to navigate the postgraduate lifestyle, because I was just about to graduate. And so I was looking at what I was going to do. But in terms of how the work has impacted my work, I think it gave me insight and it gave me knowledge. So for example, I can easily speak about CEDAW, or I can speak about the Maputo Protocol. I can speak about the African Court on Human and People's Rights, the protocols, because I got to learn about them. But I also had an opportunity to contribute to an amicus curiae that was being done by a former independent expert on the rights of persons with albinism, and one of the directors at the O'Neill Institute on National and Global Health Law. So I got to do this last year. And this amicus curiae for presentation at the African Court on Human and People's Rights, which I never thought that I would be able to do something that is at that level. But I think having the background of the Moot Court competition gave me, the ability to also be able to contribute to that kind of work. So I'm very grateful to have been able to do that. And then I think also seeing the platform also helped me to connect with other people who are in that space. So I've been applying, or I've applied for certain fellowships that were being held with the African Court, just because I think I did this last year when yeah, I did this last year, even though I didn't make it. I knew I wasn't going to make it. But I think sometimes, sometimes the exposure helps you to see other avenues that you can use the law. So right now I work in a commercial practice. So I do corporate and commercial law, but I think sometimes it's given me an eye for areas, it's given me an eye for progressive legislation. So sometimes I can be reading something that is corporate and something that is, very commercial. But sometimes I can look at, okay, how many female directors are actually sitting on this particular board? Or sometimes when I'm doing something to do with inheritance, I can think about, okay, but how does this affect the rights of women? I also think that last year we got to speak into political issues as well. So how women parties that are run by women were functioning and whether they had equal access to be able to do that. I think even though this did not necessarily change me, I had friends who were running in certain political posts. So one of my friends was elected a mayor in the last elections, which was really, really great. And she also faced a lot of backlash. A lot of young women in Zimbabwe faced a lot of backlash around the time of the elections when we were electing people to work in different constituencies. And so I had two young people that I knew very well who had been elected, and they faced some of those discriminations being young women who were in these political spaces. So I think sometimes it might not happen to you necessarily, but it might happen to someone you know. And when you have looked into the legislation and looked into the laws, you're able at least to have some empathy, or at least to realize when something is being weaponized, which should not be weaponized. So yes, but ultimately I think it gave me a practical ambition or a practical sense of what the work of a lawyer should be, which is no matter what industry you work in, you should be able to contribute to the realization and achievement of basic human rights, especially gender equality.
Thank you so much, Nadia, for sharing your rich experience and really showing the versatility of, the Maputo Protocol and other international instruments with in terms of our daily experiences as women and girls on the continent. Et pour vous, Ryan, comment votre participation vous a-t-elle influencé votre travail universitaire ou votre engagement actuellement?
Ok, merci beaucoup pour la question. Alors, en ce qui concerne, je peux dire, les acquis de ma participation à ce concours. En première position, en termes d'acquis, comme j'ai eu à le signaler un tout petit peu avant, c'est en termes de réseau auquel ça m'a ouvert. Parce que, pour la petite histoire, par exemple, moi, j'ai fini en droit, mais en option droit économique et social. En option droit économique et social. Et donc, de prime abord, certaines personnes pensent que quand on est en droits humains comme ça, on est un peu perdu si on n'a pas fait une option de droits humains déjà à la faculté, ce qui n'est pas du tout vrai, parce que déjà, même chez nous, en droit économique et social, nous avons déjà ces options-là. Et donc, en ce qui concerne ma propre, donc, d'abord mes perspectives, après directement le concours, directement au retour dans mon université, j'ai entrepris avec mon camarade avec lequel je participais, Monsieur Bahati Pacifique, à pouvoir créer déjà une structure bien ficelée au sein de la faculté pour d'abord l'organisation au niveau interne de certains procès simulés sur certains objets de droits humains. Ça, c'est en première position. Mais en deuxième position, c'est cette même structure-là qui prépare déjà d'autres étudiants à la participation à ce type de concours tel qu'organisé par Coalition. Donc, ça, c'est en termes d'un acquis principal parce que je me suis dit que l'une des choses que je me dis toujours est que l'important, ce n'est pas ce que nous avons ou bien ce que nous avons vécu, mais surtout ce que nous en faisons après. Et pour moi, ça a été la première expérience, avoir acquis des Coalition, mais aussi pouvoir transmettre ce que j'ai reçu des Coalition. En deuxième position, bien sûr, ici à Bukavu, finalement, nous avions décidé de pouvoir nous entreprendre aussi à organiser ce type de procès simulé, non seulement dans le cadre de notre faculté, mais aussi dans le cadre de certaines structures ici au niveau local, au Sud Kivu, au Congo. Et cela a finalement quand même donné, parce que nous avions organisé 2 à 3 procès simulés dans ce sens-là, tournant autour d'abord des droits humains en général, du droit international humanitaire aussi qui s'est invité, naturellement. Et puis, vu que nous sommes dans une zone assez à risque sur le plan sécuritaire et au niveau de la guerre, mais aussi sur le plan des droits des femmes, parce que c'est une question qui est très épineuse aujourd'hui, malheureusement, très malheureusement, c'est une question qui est encore épineuse. Il y a encore ceux-là qui se disent que peut-être c'est un droit qui est utopique, que ce n'est pas réalisable, que l'égalité est inefficace ou bien euh, ineffective, etc. Mais aujourd'hui, personnellement, moi, j'ai eu à connaître de grandes dames de ma très faible expérience de grandes dames. J'ai eu à partager des sujets de recherche, des objets de recherche avec de grandes dames. J'ai connu même Nadia Moutisi, une vraie battante, très forte là, très chaude là. Et ça, c'est très intéressant. Quand on apprend à connaître ça, on a une autre vision de la femme. Et pour moi, le meilleur apprentissage que l'on puisse donner des qualités de la femme, euh, un grand apprentissage que l'on peut donner, une grande expérience que l'on peut donner de qualité de la femme et de l'égalité qui existe certainement entre la femme et l'homme, ce n'est pas beaucoup de choses. Ce n'est pas seulement un texte, ce n'est pas seulement un protocole, comme le protocole de Maputo. C'est seulement que toutes ces personnes-là puissent rencontrer ces mêmes femmes, comme Nadia, comme des profs que nous voyons aujourd'hui, seulement les voir, les rencontrer, les affronter, les connaître, les entendre, et ils auront à avoir cette expérience-là. Et c'est ainsi qu'avec ces types de procès simulés, surtout avec une riche participation des femmes, de jeunes filles, même jusqu'au niveau secondaire d'ailleurs, parce que nous avions aussi organisé des concours d'éloquence, là seulement de l'éloquence, quand des gens connaissent ce type de femme, qui peut sortir même meilleure plaideuse d'une compétition, ils savent la valeur de ces femmes-là. Parce que pour moi, aujourd'hui, la question de l'égalité du genre, ce n'est pas une question de savoir s'il y a des textes ou pas. C'est aussi une question de savoir qu'est-ce que nous faisons de ce texte-là, et en réalité, au regard de nos cultures, pour savoir si ces textes vont être applicables ou pas, il faut que l'on sache ces textes seront applicables à qui. Et bien sûr, c'est applicable à la femme dont la valeur semble encore ignorée aujourd'hui. Et je pense que progressivement, la lutte que fait Equality Now, c'est une lutte qui est noble. Et beaucoup d'autres structures, beaucoup d'autres ONG, c'est très important de pouvoir faire cette lutte-là. Et pour moi, aujourd'hui, je me mets toujours dans cette posture-là, à toujours valoriser la femme dans tout ce que l'on fait et à toujours continuer dans ces luttes-là, non seulement de vulgariser des textes en matière de protection des droits de l'homme et des droits des femmes, mais surtout une lutte à pouvoir permettre à ce que la femme puisse avoir une palette d'opportunités pour qu'elle puisse s'exprimer, parce que c'est très important qu'elle puisse s'exprimer, qu'elle puisse être entendue et que les gens qui l'entendent puissent être aussi informés, non seulement de sa valeur au sein de la société, mais aussi et surtout de sa place telle que déjà reconnue par les instruments juridiques nationaux, mais surtout et surtout internationaux.
Cool. Merci beaucoup, Ryan. And really, thank you so much also for sharing, the realities in DRC and, the vision that you have in terms of where this can be applied, but also the efforts that you're taking to ensure that what you gained is also being transmitted to other people. And this is all part of popularizing the Maputo Protocol. One of the people who's joined us on this panel is Dr. Harrison Bori, who has many years of coordinating, mentoring, and judging moot court competitions. Harrison, if you could please tell us, from your experience with all these different moot courts that you have been engaged in, what are the key things that really stand out for you with the Africa Gender Equality Moot Court competition?
Thank you so much, Esther. I hope you can hear me and possibly see me.
Yes, perfectly. Thank you.
Thank you. Tell me if there's any technical issue. So first of all, I want to thank Equality Now, all the organizers, all previous speakers who have spoken. It's been such an enriching experience. And also that we are having another session of this moot court competition this year, which is vital for our students all over Africa. I think to just answer your question directly, I will say that there are three specific points that stand out for me that make this moot unique, different from the other moots that are out there and that I've been involved in. The first one is substantive. It's the substantive aspect of this moot that is actually very important. While indeed it is a human rights moot, and there are a number of other human rights moots out there, this Moot's specific focus on the Maputo Protocol and pushing the aspects and the agenda of the Maputo Protocol, I think makes it quite unique. This is because it's quite an important protocol for women specifically in Africa, and it is important that people get to know about it, stakeholders push its knowledge both to students who indeed are going to be future practitioners. And to my knowledge, I don't think there is any other specific Moot that fronts or front loads the Maputo Protocol like this Moot does. And therefore, that makes this Moot very unique. Secondly, and I think also importantly, but now from a procedural point of view, is actually setting up the Moot in the African Court on Human and People's Rights. I think this is indeed the flagship regional court that deals with human rights issues. And I think, therefore, it grants our students an opportunity to engage in human rights aspects in a very special way, and also gives them an idea about the processes of protection, promotion of human rights in Africa. So then having this setup, this Moot setup in the African Court, I think it's also a special aspect of this Moot. It is not it is not unique specifically for this Moot. For other Moots also normally use the African Court as a specific venue for the setup of their Moots. But I think that the choice of the African Court is indeed an important choice for purposes of this Moot. I would also add just finally, one thing that makes this Moot special is, of course, its interest in ensuring that it covers as much of Africa as possible, including having both a Francophone and an Anglophone content. I know in Africa it can get very complicated because once you include Anglophone and a Francophone component, there's a likelihood that some Lusophone countries will also claim, why not us? I hope that this is, even as the Moot grows more and more, and even as more participants get interested, this is important. But the fact that there's these two separate components of the Moot makes this Moot important and vital for as many students in Africa as possible. Thank you very much.
Thank you so much, Harrison. And you've really started to speak about, some of the possible benefits that, students wishing to participate in this could get from the Moot Court. Would you like to add anything in terms of benefits?
Yes, I think there are many sort of benefits that I can say that this Moot has. One specifically is the reinforcement of knowledge that is already learned in our different universities and classes. I know that this subject is taught in different schools under different headings. Sometimes it's called gender and the law. Sometimes it's called women in the legal process. There are all kinds of names that are given out there. And I'm not sure whether in many schools this is a compulsory subject along many law schools in Africa. So this gives an opportunity for reinforcement of the knowledge if a student has learned this in their university education, or possibly this is absolutely new knowledge that a student is going to gain. So here you can see that then the Moot Court grants a huge benefit in terms of raking up knowledge that ordinarily the student would not have been able to gain elsewhere. And I think even for us sometimes as professionals, it's very good knowledge. I personally, I think on the question of surrogacy, it's a new topic to me. And even just attending this session today, there's just so much knowledge that I've been able to, new knowledge that I've been able to gain. So, everyone is gaining in different capacities. Then I think that the Moot also is vital for purposes of preparing students for rigorous careers if they are interested in areas of human rights, in areas of public interest litigation, and even in applying questions of human rights when they end up in areas that are not necessarily human rights related area. Like we have seen Nadia mention that she's working in a corporate space, but is able to sort of leverage this knowledge in ways that we think are important for purposes of our students getting to know the importance of this Moot. And therefore, I think that when students participate in this Moot, they get an opportunity to prepare before entering into areas of practice that might require this knowledge. And it's not just legal practice, but there's many other areas, including areas of advocacy, that knowledge in this knowledge of that they can gain from this specific Moot can give them. I have two last ones. I think this Moot also benefits students and even professionals who are involved in terms of networking. I personally, having done this now, I think for a couple of years, I've met new friends whom I've coordinated with in other areas, and they've helped me, broaden my professional space. I think this is vital for students who want to enter into different areas of practice, who want to enter into different areas of connection. I think that networking opportunity is vital, is good for students, and I normally encourage students to really take that aspect of the Moot very seriously. Sometimes because of the competitive edge of the Moot, the students tend to focus so much on the competition that they forget that, they can meet other students here, they can make friends across the continent here, they can make new networks across the continent here. And I really do encourage students to take this as a good opportunity to meet other people, to engage with other professionals, to engage with coaches from other universities, to get to know what other universities are doing that is different from what is happening in your university. And that sort of encourages, current collegiality, future collegiality, and knowledge of what is happening in other parts of the continent. Lastly, but also importantly, even though this Moot has different components, some of which are online, and I think we can possibly think of that as a very good thing. Some Moots after COVID completely dropped that online aspect. I'm happy that we have maintained it. I hope that we continue maintaining it because it has the potential of giving more students an opportunity, but also the fact that we also have a physical component of this round, and because students are coming from different parts of Africa and are coming into Nairobi or in future in other places, this grants possibly an opportunity for students to have international travel and international exposure and go to countries and places that they have never gone to before. And that also sort of opens up their minds. They see different things, they see different people, they see different places, and that in itself has its own educative component. So I think that, these are just some of the benefits I can point out. This is a topic that you can clearly see I'm very passionate about. So I can talk about this for a very long time. But Esther, let me stop there for purposes of time, and we can always engage more.
Thank you so much, Harrison, for those very rich insights. And really, I think the Moot Court competition this year is really blessed to have you and the team of coordinators working with Equality Now, Kenyatta University, and the SOAWR Coalition in delivering the third edition of this Moot competition. You've brought us to where we're kind of going towards the end of this panel, which is about sharing insights and words of counsel and advice. And I'd like to bring in Marion Ogeto, who's our program officer here at Equality Now. Marion has been a Mooter for so many years. She really is, one of the brains behind the development and the planning of the Africa Gender Equality Moot Court competition. Marion, if you could please speak to us about, your overall outlook of the AGEMCC and offer words of insights or counsel to the students who might want to participate in this year's edition.
Thank you, Esther. And also just give a rant a lot about surrogacy, and definitely an issue of interest to me as well, as I'm sure others in the room. Onto your question, I think for me, the privilege that I have is that I stand on both ends, which is that I've participated in this competition or a model of this competition previously. And I've also been able to engage in the coordination, in the formulation of the AGEMCC up to where it is today. What I would say is that being someone who's also very passionate about mooting, and something that I was able to engage in when I was doing my undergrad, is that mooting is really special because it enables you to truly understand the issues. And I would give the example of, for me, when I was participating in this competition, it was a gender equality moot court competition, but at the national level. And the theme that we had that year was political participation of women in Africa. And being someone who already had some form of interest in women's rights, I had a glimpse of, a general understanding of the issues, because it's also a really big topic in Kenya in terms of the 2/3 gender role. But now from the moot court competition, or from the hypothetical question, it forced me to really dig deep to be able to understand the actual situation, not only in my country, but also in other countries in Africa. So from the competition, I was able to understand, for instance, the situation of political participation of women in Rwanda, in Zimbabwe, in Uganda, in South Africa. You sort of become an expert in that area, and it forces you to really dig deep to understand how you can be able to use the law as a tool for change through now the mechanism that you're going before. And now for the AGEMCC, it's now the African Court of Human and People's Rights. So it really opens your eyes, and I would say it builds a solid foundation, because even as Harrison and I think Nadia have spoken about it, you may have maybe gotten a glimpse of the Maputo Protocol, or you may have heard about it, and even for some, you've never even heard about it. But as you're engaging in the competition or participating in the competition, you have to really read through it, and it helps you to open your eyes and to truly embrace how special and how unique it is. And it brings it home, so that it's not only it's not something that seems far remote. You're able to sit down and see, we have this very beautiful instrument that is for all women and girls in Africa. How can we be able to make use of it extensively to cure or to solve the problems that we are seeing in our continent? If you look at the Maputo Protocol, it speaks about harmful practices. It speaks about the rights to the reproductive rights of women and girls in Africa. All these things which are very alive to all women and girls every single day in Africa. So I would say the beauty of it, I think, as everyone has mentioned, is that it really helps you to see how best you can use the law, and especially the Maputo Protocol, to solve the issues that are facing women and girls today. So for anyone who is thinking about competing, or anyone who's thinking about participating in the competition, I would say, please do it. Don't even doubt yourself, just do it. And another word of advice I would say is that, for me, the first time that I participated in the Moot, in the National Gender Equality Competition, was the first time I participated in a Moot outside, not an internal Moot in the school, because I had done, I think, a couple of internal Moots in school, but I had never done an actual competition. And the first time I did it was the first time, and it was the first time I did it, and I actually, became successful. So I would say, please go ahead, participate, register. There's a lot of benefits, as Harrison has mentioned. There's a lot that you will be able to learn. And even more so for me, I'll say I'll connect it with the other end, because I participated in the competition, and now I'm working at Equality Now. And this came from me participating in the competition in 2017 when I was in school. So it really helps you to connect in terms of engaging in protection and promotion of women's rights as a lawyer. So when I was doing the competition, I was interested, but I didn't think it was actually possible for you to do this as a job, if I'm being honest. And I think it's something that maybe Nadia has mentioned a bit, which is that it always seems very far removed. You going before the African Court or the African Commission, it's not something that any person will just imagine or envision themselves doing it. But when you engage in these competitions, and even including the AGEMCC, it enables you to see that it's actually possible for you to engage in legal advocacy, in strategic litigation, in all these other things that we do on a day-to-day to ensure the protection and promotion of women's rights. So there's the benefits that you'll accrue in terms of building a solid foundation to understand the law. And then there's also the benefit of connecting it to in the form of your career, to actually see that it's possible for you to engage in it even after school.
Thank you so much, Marion, for your insights, and really just to acknowledge all the hard work that you have put in over the years to make sure that the AGEMCC is what it is today. For Nadia and Ryan, and I'll ask this in French. One last question. Marion and Harrison have given some great ideas and and advice. Quel conseil ou idée souhaiterez-vous partager avec ceux qui voudraient participer à l'AGEMCC de cette année? C'est juste en bref, dans 30 secondes. Ryan, commencez.
Ok, voilà, oui, je suis là. En tout cas, pour être bref, pour être le plus bref possible, la seule chose que je peux dire à ceux qui sont en train de participer, c'est la même chose, participer et profiter. En tout cas, sans passer par beaucoup de choses, participer et profiter de cette opportunité. Aujourd'hui, plusieurs personnes en profitent de différentes manières, mais pour moi, participer, profiter et bien sûr, construisez-vous alors une coquille, une idée, une conception de cette expérience à vous-même et à faire valoir dans vos diverses communautés.
Merci beaucoup. Et Nadia?
I'm sorry, Esther. I'm not able to hear the
Oh, you
translation.
didn't get the translation. Sorry about that. So just very briefly in 30 seconds, what words of advice or ideas could you give anyone who wishes to participate in this year's AGEMCC?
Okay. I think that you really need to read widely, and I think articles can also help. So last year I came across this article by Mame Efua Adadzikum, where she spoke about the due diligence principle. And I really understood it. And if you watch those videos, I really went home with it. So I think there's need to read, apart from the legislation, to also read other people's opinions and thoughts. And to have fun. I think when you and your mood partner have a great synergy, it really creates the best results. So I think I saw that with Pacific and Ryan. I think you could also see the same thing with myself and Faro. We were really good friends, and I think it really helped our participation in the mood court competition. Yeah.
Fantastic. Thank you so much. Merci beaucoup de nous avoir fait partie de vos expériences et de vos idées. J'espère que vous avez inspiré des autres étudiants à participer à la JMCC cette année. Désolée pour, j'ai déjà prendre beaucoup de temps, mais maintenant je partage la parole à Liz, s'il vous plaît. Over to you.
Thank you so much, Esther. Thank you, the panelists, for sharing their amazing experiences and insights. So right now on our agenda, we're just going to discuss the next steps. As Esther has mentioned, this year we have a team of Moot Court coordinators supporting us with the Moot. So I'm going to invite Michelle to just give us the next steps, sharing the details on registrations and other needed things for the Moot Court. Welcome, Michelle.
Thank you, Liz, and good afternoon to everyone. It's a pleasure for me to be here with you today. As Liz mentioned, I'll be working with the equality.
Michelle, we can't hear you well. If you could just increase your volume for the interpreters.
Is it better now?
I think you might have to shout a bit. Just speak louder.
Is it better now?
Yes. Interpreters, will that work?
Okay. Thank you, Liz. So I'm just going to take you through the next steps. Please just confirm, will I be sharing the PowerPoint from my end?
Are you already sharing?
Should I share it from my end?
Yes, please. Yes, please.
believe you can see my screen.
Yes, please proceed.
Great. So in terms of next steps, a registration link is to be found on the Equality Now website or page, through which you can register as teams for the competition. In terms of the eligibility for you to compete, of course, you need to be a student enrolled in a university in Africa, and you should be currently pursuing an undergraduate degree in law. Of course, you can be a part-time student or a full-time student, and you need to be in one of the participating institutions during the calendar year of the competition. The format of the Moot this year will be a hybrid format as in other years, and it will incorporate both virtual and in-person rounds, and I think this has been made clear throughout the presentations today. The preliminary rounds and the quarterfinal rounds of the competition shall be held virtually on Zoom, and the semifinals and finals and the award ceremony shall take place in person, and this shall happen in Nairobi, Kenya, and I'll come a bit to this detail later. The rules of the competition shall also be published alongside the competition hypothetical question itself, and these rules will outline the style, the format, the grading criteria for submitting written arguments, that's the memorials, as well as the format and grading criteria. All this information shall be available in the website. Of course, one thing that's always relevant for competition is whether you'll be awarded for the different categories, and there will be awards for the best team, the best orator, and the best memorial. In terms of timelines, today being the 25th of July 2024 will mark the launch of the Africa Gender Equality Moot Court competition. The registration shall open next week on Monday, that's July 29th, 2024, with a hypothetical case being published on the website alongside all attendant rules and all details that will be relevant for your participation. So from the 29th of July, you'll have until the 6th of September to raise any clarification questions that you may have in relation to the hypothetical case. So that gives you a good time to interact with the hypothetical, scintillate the facts, and develop any clarification questions you may wish to be resolved. Registration shall close on the 30th of August, and after registration, you shall have until 13th September 2024. The team shall have until 13th September 2024 to respond to the clarification questions that you'll raise. You'll have until 27th September 2024 to submit your memorials. So between when the registration opens, which is on 29th July 2024, that's next week on Monday, you'll have until the 27th of September 2024 to write your memorials and submit them. Of course, the rules relating to submission shall be in the rules that shall be published next week. The teams that shall be accepted based on the memorial review that was discussed earlier by Esther shall be communicated on the 4th of October 2024. A few details that I think are also relevant to highlight at this moment. I think it's very important for you at this point to have valid passports. This is regardless of whether the communication of semifinals or finals has been shared, because as you'll note from the timelines, the time between a qualifying team being notified and the actual rounds of the semifinals and the finals taking place is very short for you to be able to get a valid passport. So it's important for you to have a valid passport, even by the time you're registering, just in case you qualify. At any rate, it shows that you actually have great belief in your team that you'll get to the semifinals and the finals. So we highly encourage that you have your passports ready by the time of registration to avoid any inconveniences once you qualify for the semifinals and the finals. In terms of travel and accommodation, Equality Now shall cater for the travel and accommodation, particularly transport and your accommodation for the participants who will be traveling to Kenya for the semifinals and the finals. Lastly, Equality Now shall also be providing visa support documents for those teams that shall qualify for the semifinals and the finals in Kenya. Thank you for your attention. For any inquiries, please write to genderequalitymoot@equalitynow.org. And that's the website where you shall be able to find the Moot question and the rules. Thank you very much, and I hand it over to you, Lee.
Thank you so much, Michelle, for sharing the next steps. Right now, I'm going to invite Ms. Margaret Kokumu, who's the registrar, Kenyatta University School of Law. Apologies for that. To just share a few remarks.
Hello. Thank you so much, Elizabeth. I'm so grateful and sorry for the technical issues that I went through. I've now decided to use my phone. In respect to the highly esteemed protocols and personalities that we have had in this launch, from Equality Now, the Worthy Partner, Solidarity for African Women's Rights, Coalition, invited guests, and equally backed by the invaluable protocols of Kenyatta University through the Office of the Vice Chancellor, the Office of the Executive Dean and Deputy Executive Dean of the School of Law, Arts and Social Sciences. Ladies and gentlemen, I am sure that you feel welcomed in this third edition of the African Gender Equality Moot Court Competition. As indicated in the invitation letters that we received, that I believe you also received, this launch was primarily an educational session. And you will agree with me that you are highly enlightened on the theme of the continental competition, which is commercial surrogacy in Africa. Indeed, every speaker's intention was and actually achieved to challenge the potential participants, thrusting them into the academic rigor of comparative research on legal standards, seeking to find the convergence stands in women's and girls' rights in Africa and international law. We have noted that in most African states, legal education in institutions of higher learning is loaded and progressive in design. It is both foundational and developmental in raising legal practitioners. And when we have a graduate or a student of law, you are actually trained in institutions of higher learning like the universities to be either an advocate or a judicial practitioner or an educator. Maybe you may end up becoming a tutor, a lecturer in institutions of legal education. So you can really see that your experience during your education and training is loaded to make you become somebody that is a worthy career personality in legal lines. So part of the strategy to develop you well is this Moot competition. Why? Because the Moot competition gives you a chance as a student to put what you have learned into practice. It develops your capacity to participate. It develops your capacity to institutionalize and implement best practices in your legal careers. So as you have already been welcomed into this great journey, I want to assure you that it is a real great journey in your legal career. This is the time for you as a participant to remember to launch deep into your intellectual rigor, convictions, creativity, and production. You are set to do research. You are set to collaborate. You are set to question that which you have learned and really to put into practice the theories that you have been having in class. I want to thank the Equality Now and the planners for setting the context, which is really a context that is exploiting the immense potency in the current generation of students. That involves teamwork, digital ecosystems. I'm sure we are going to communicate more. We'll have virtual meetings. You will do your research online, and even within your campuses, your academic institutions, in the libraries that are there. So we hope and trust that this experience, as has been witnessed today, we have had those who have given their testimonials of how this experience has changed their lives and their careers to date. Therefore, we would like to challenge the students that are here with us, that we are very excited as an institution of higher learning to be part and parcel of this great journey, to train you and make you into best practitioners, because I think that is at the core of Moot competition. Curriculum in its design in the higher institutions of learning is supposed to give you all the best and train you as a workforce in the community outside. And I'm sure that is not going to fail when we take our mooting competition seriously. I want to quote some words from a renowned professor. Once said that a university is for science, and science is for the society. The freedom of science and its creativity, academic autonomy, works well in the social sciences for the motherland, for the society, and humanity. These are the guidelines of the university. And I want to take this opportunity to really wish the best team the best. We would be happy to see great works of research, of convictions, of teamwork. That is why the accolades are for the team and individual contributions. Thank you so much. Feel welcomed. Thrust yourself into the research, into the teamwork, so that we have the best of the Moot competition so far. Thank you so much, Elizabeth.
Thank you so much.
Thank you so much.
Right now, please allow me to invite Samia Melki, a SOAWR member of the Solidarity for African Women Rights Coalition, to just give us the closing remarks. Apologies for going over time. Welcome, Samia.
Hello. How are you, everyone? So happy to be with you today. My name is, je vais parler en français. Voilà, je suis Samia Melki, je suis la présidente de l'association Qadirat, qui est membre de SOAWR, Coalition pour les droits des femmes africaines, solidarité des droits des femmes africaines. Donc, au nom de la coalition SOAWR, d'Equality Now et de la Faculté de droit de l'Université Kenyatta, je tiens à remercier toutes les personnes et organisations représentées aujourd'hui qui ont pris le temps d'être avec nous et d'assister au lancement de la 3e édition du concours de plaidoirie pour l'égalité des sexes en Afrique, AGEMCC, en tant que membre de SOAWR et en tant que ayant servi en tant que juge dans les précédentes éditions, je n'ai aucun doute que le tribunal fictif pour l'égalité des sexes en Afrique donne aux étudiants l'occasion d'explorer divers droits des femmes tels que prévus par le protocole de Maputo. Aujourd'hui, je suis donc ravie de voir autant d'esprits juridiques brillants et en herbe, prêt d'attaquer ce sujet très intéressant. D'ailleurs, il faut aussi, je vais être franche avec vous, je n'ai pas beaucoup d'informations sur le sujet des femmes, des mères porteuses, et d'ailleurs, je vais d'ores et déjà commencer à étudier le sujet et me documenter là-dessus. Voilà. N'oubliez pas que cette compétition ne se limite pas à gagner, non. C'est l'occasion d'apprendre et de préparer son avenir dans la profession juridique en s'attaquant au sujet qui concerne les femmes. Je tiens à remercier nos animateurs, les coordinateurs des tribunaux fictifs et les conférenciers pour leur contribution inestimable lors du lancement d'aujourd'hui, ainsi que les interprètes qui ont rendu notre communication transparente et facile. Je profite de l'occasion pour souhaiter aux étudiants tout le meilleur dans les prochaines étapes. Nous espérons que ce concours sera l'occasion pour vous tous d'apprendre. Merci encore une fois d'avoir participé. Avant de terminer, je voudrais également demander à chacun d'entre vous de partager intensivement l'annonce de ce concours sur vos réseaux sociaux, sur vos sites web, en parler autour de vous pour que la communication soit plus efficace et qu'un plus grand nombre puisse participer. Donc, nous sommes impatients de voir les esprits juridiques créatifs que vous représentez dans le cadre de ce concours. Bonne chance avec la compétition. Merci aux universités d'avant et à cette université cette année-là d'avoir participé et de nous avoir donné l'occasion de participer. Merci beaucoup à tous. Et merci à Elisabeth et à Esther et à Faiza de m'avoir donné l'occasion de faire le speech de clôture. Merci beaucoup.
Thank you so much, Samia. Merci beaucoup. The third edition of the AGEMCC is officially launched. So please be on the lookout on the Coalition website on Monday for registration and other documents. Thank you so much for making time. Merci beaucoup. Bye.